Judgment item number 1501.
Your Lordship, I appear for the petition.
Please.
We have held that it was not necessary for the appellant to fall back on the 2012 contract to invoke the arbitration clause because the 2016 contract, though it was not signed by respondent number 1, was acted upon, accepted and acted upon by both parties, and therefore the arbitration clause therein would bind both parties. The appeal is accordingly allowed, setting aside the judgment of the division bench and the order of the learned single judge. In consequence, AYAN number so-and-so in the suit shall stand restrained to the file, and the disputes between the parties shall be referred to arbitration by the referral court in accordance with law.
Very grateful, Your Lordship.
Statement 801.
801 not necessary because it's listed today. Council obviously.
Item 802.
802 29th August.
Much obliged.
803.
18th November.
804.
24th September.
805.
19th November.
Number
830.
One who appears for the responsible. The co-accused has been granted.
The co-accused has been granted.
Therefore, he stands on par with.
He just surrendered late, members. That's why he was also served. Right now, he said about 22.
He is the main accused. As the co-accused, who is stated to be the main accused, has already been granted relief by this court. We find no grounds to deny the same to the appellant relief granted. The appellant should, according in the event of his arrest, in connection with he's in jail, is it?
He's in jail.
The appellant shall accordingly be released in connection with filing the charge sheet very soon on terms and conditions to be fixed by the trial court. He shall cooperate during the trial.
No, the trial is concluded.
Trial is concluded.
The appeal. This is an appeal.
Why is this is the appeal? So it's then only conditions to be concluded.
Lordships have already granted leave.
Yes.
Yes.
Leave is also granted.
Both.
Only the IA there.
Yes. I'm great.
item number 2.
Well, as I'm for the petition, I'm seeking time to file rejoinder.
Rejoinder.
Well, as interim order shall be.
Then counsel for the petitioner seeks time to file a rejoinder. Needful in that regard shall be done within 3 weeks. Just on 23rd September. Interim order dated 25/11/2024 shall continue.
In item 3, I'm appealing for this. I seek some 3 weeks time to file counter.
3 weeks and time to file.
I'm appealing for the petition, my lord. There is some error. I'm please, your lordship.
Yes, from
I'm appealing for the petition, item 3.
7th. Item 3 will need a counter because it is.
My lord, there is some error.
Quantity.
My lord, there is some. And I am seeking, my lord, there is some error in the
Your
gross
voice
for
is
interim
not
leave.
clear. Council, your voice is not clear. In any event, we'll need to have a counter affidavit because it's a commercial quantity. We can't grant you relief without hearing the state.
My lord, some error is there. I rectify that error in the prayer for interim relief, my lord. Your lordship may permit me to, instead of speaking a bail, my lord, in the prayer, my lord, some error is there, my lord.
You want to amend your prayer.
My lord, my lord.
Whatever it is, you file an IA that will be considered.
Item 4.
Item 4.
Please, Your Lordship.
I appear for the state in item number 4. It's a regular bail. I need 3 week time to counter.
So for the state, 6 some time to file a counter. for the state seeks sometime to file a counter that with an usual order, date 14th October.
Item 5.
So in item 5, then the double is restricting my lords.
Lordships, may I humbly submit, Lordships, I'm here.
Stated to have expired.
Lordships, there is a small request in this matter.
Yes,
The district judge who had been directed by my lords to
He's
conduct
expired.
the inquiry, yes, Lordships. So
Any-
Lordships, no new judge has taken the post as
there
of
would
now.
be an additional judge at least. Some ad hoc judge would be there.
ADJ one is the acting judge, Malad.
He is the,
Yes,
whoever is
ADJ.
now acting as the principal district judge can submit a report.
Lordships, what we can suggest, if at all, Lordships, the Gautam Budh Nagar district judge can take it.
No, why
up.
should there be another different?
Lordships, may direct accordingly,
Yeah, so
Lordships.
This, where is that letter? As we are informed that the principal district and sessions judge Ghaziabad, namely Shri Ashish Garg, is no more the acting oblique ad hoc principal district judge of the said district, may undertake the inquiry as directed by this court on
25/6/2025.
25/6/2025 and
No.
submit a report.
Grateful.
Give a date. So it's 14th October.
Grateful.
Item grateful.
Yes,
Your Lordship, I'm appearing on behalf of the state. seeking
item
to-
6.
Yes, you.
Very- Tondaraga pilvani. Tondaraga. The state seeks some time to file a counter. All
Okay,
these
so-
matters where you needed to file a counter, could you have filed letters? Some of the council have done it, but a lot of the others have not. We need to go through the matter and then you just come up with a simple request for a counter.
Apologies, Your Lordship, we'll do it next time.
If you need time to file a counter, just file a letter and say so.
Yes, Your Lordship.
And then comes usual order, date 7th October.
4 weeks, Your Lordship.
Yes.
Was already filed it.
State's counter.
I think 2 weeks time.
Same thing applies to you.
Yes, ma'am.
And council appearing for the state seeks some time to file a counter. If you want it, and reply also, then that is joined date. 7th October.
Enter to them. Item 7.
7, rejoinder these things.
Very well.
Item 8, no counter. 8 also.
Mileage.
8 also.
I apologize.
8 also same.
Please, ma'am.
7th October.
Item 9.
9, no counter.
Please,
No counter, but some IA seems to have been filed.
please, Lord. It was for execution, stay on the execution of NBW
NBW has now been issued.
issued not without serving any.
By the state.
The counter has been filed, Lord. We filed the counter, Lord.
No, you don't
As
have a
regard-
counter.
I have not received the.
What is Lord?
9, there's no counter.
Lord may not be on judicial report.
Sorry, the office report also says no counter. Office report is dated 23rd August, it says no counter,
Your apology on Saturday it has been filed.
without serving on the other side.
No, sir, we have
He says he's not been served.
Not serving.
in all the
And
provinces.
someone who's been under protection since 6th December 22, you need to issue a NBW against him.
Lord, that part because IA is yet to be received by me.
Learned council appearing for the state of Uttar Pradesh says that the counter affidavit was filed on Saturday. However, we do not find the same on record. Learned counsel for the petitioner also states that he has not received a copy thereof. Learned counsel for the state shall do the needful in that regard. List on
So meantime.
16 September. In the meanwhile, the non-bailable warrant stated to have been issued against the petitioner shall remain stayed.
Other activity also.
10. This also is mine.
Hello? This Secretary Bill. I'm charged.
This lady is in prison, is it?
No, my lord.
Please look at page 21 in the FIR.
He's on.
In the FIR, about 10 lines, the applicant is in jail. The applicant being the complainant there.
Yes, my lords.
She's in jail, is it?
No, my lords. This is a typographical error.
Please.
My lords, anyway, she's still up and down.
In bed. Is returnable on 14th October. Service shall be effected by all modes, including this. The subject to the petitioner cooperating with the investigation in FIR number so. He shall not be arrested till the next date of hearing.
Let's.
Your lordship is requesting for the week's time.
I'll account. You're for the state.
This is
State?
Yes.
a big.
Others are served? There's
The
others
others are co-accused, my lords. So performer.
pro forma.
Yes, my lords.
They're not served.
Because all 5 of them had filed combined the bail application before the High Court. So they are the necessary party, but the state is served.
Then counsel for the state of Rajasthan seeks some time to file a constitutional order. Then placed on 14th October. 14th October.
So let's may dispense with the service of others, my lords.
Let us see any of the.
There are others.
Process is-
Others are co-accused, my lords. Anyway.
You
In
need
jail,
to
my-
file an application.
in jail, my lords. There.
File an application.
I'll do that.
One more.
May it please, my lords. It's fresh. I'm in custody for now, my lords, 29 months. That's 2 years, 5 months.
13 have been granted bail.
Everyone has been granted
No,
bail.
but you were on the way to Dubai.
So are the 2 others who've been granted.
Stashed away all the money.
Those 2.
10 crores diverted to your family members.
Out of 1,700 crores that they say, which becomes 2,400 crores, my lords. Granted bail, my lords. Kindly consider it. What should we do?
Issue notice returnable on 28th October. Service shall be effected by all modes, including justice.
Obliged.
May I please, Lordship, petitioner is in jail
Yes.
for 7 years and 3 months.
Cause of the matter, direct that the issues should be brought to the notice of the Chief Justice so that this bail application is not treated like some ping pong ball and sent
2
from.
years, I am from pillar to post, one
This is
judge to
incorrect.
another.
This
judge.
procedure which the High Court is following is completely incorrect. If at all they have a standing order, the registry of that High Court should be a little more.
Now Lordship has clarified this position.
From the.
Lordship, may I just point out, now this position is clarified by the Lordship in the judgment, where the previous view was that the bail application from same crime shall go to same judge. But here,
That's a different one.
but
That was
what
just
say,
a revised order while I was sitting with
the
him.
judge
said
who
that
had
in UP, each bail application, even from the same FIR, goes to a different judge.
yes,
And completely subjective
yeah,
application of mine by each judge.
yes. Now then his position
Now
is
that-
clarified
This is now,
that
this is now
the judge is sitting in division bench, then
they have a standing order of the Chief Justice in the High Court there. So once there is a standing order, we can't override the standing order.
logic.
Therefore, let it
Tomorrow,
the
matter
of the
is
Chief Justice.
Just
thereafter.
say, tomorrow matter is listed before an honorable single judge. Now this matter got transferred to the Kolhapur circuit bench. And tomorrow matter is fixed.
Before the same judge.
No, not before same judge. It is before another judge.
Then again, same issue will arise there.
But if Lordship will see page 214, if Lordship can see Lordship's judgment, then Lordship could direct.
That judgment is entirely different.
No, this is a.
That it was not in a case where there was a standing order of the High Court's Chief Justice.
Lordship just see page 214, para 9.
Yes.
Previously, Lordship noted that judgment and then said, we are therefore of the view that if aforesaid direction is followed universally, it may lead to disruption of benches in as much as learned judge who had initially heard the bail application of one of the accuser may have become a part of.
This is in the case of all bail applications arising out of a single FIR. That is not the standing order here.
Yes.
The standing order of the Chief Justice is if one judge dismisses the bail application,
the
second bail application of the same person should go back to the same judge.
Then
it's entirely different. Counsel, don't waste time. The record, perusal of the record reflects that the bail application number 3213 of 2023 is not being resolved till date, as it is being posted before one bench after the other in the light of the standing order dated 31/8/2023 of the learned Chief Justice of the Bombay High Court, requiring the very same learned judge who dismissed the first bail application to hear the subsequent bail applications of the same of the accused. Full stop. In the light of by virtue of the said standing order, a bail application cannot be kept pending indefinitely, and it is for the registry of the High Court to ensure that the standing order is given effect to, so that the bail application is dealt with expeditiously. We accordingly dispose of this special petition, directing the Registrar General of the Bombay High Court. He's called Registrar General or something else?
Registrar General. But now
General of the Bombay High Court to place the matter before the Honorable the Chief Justice of the Bombay High Court for appropriate orders to ensure that such lapses do not occur, and to also ensure that bail application number so and so 3213 of 2023 is placed before the appropriate court for expeditious disposal.
Item 14.
The special petition is disposed of.
Lord, in 14 Lord, the request is for grant of anticipatory bail. Lord, in the present case, Lord, I am neither the signatory nor the beneficiary. Lord, the only allegation against me that I have introduced, Lord, the complainants with the persons, Lord, with whom they have entered into a deal.
You also produced fake Aadhaar cards for those fake.
No, Lord, not mine, Lord. It is they same, Lord. These are by two persons. Lord, meanwhile, Lord, may protect me.
In the meanwhile, subject to the petitioner cooperating with the investigation in FIR number 137 of 2023, he shall not be arrested.
Please, Lord. I am deeply obliged.
But 3 years, 10 months in custody, not even 1/3 of the trial.
What about the magistrate? Has he been examined?
No, Lord, the Tehsildar has been examined.
You said 6 witnesses were examined.
3 police officers.
The gazetted officer has not been examined.
He has been examined.
What does he say?
Lord,
You said that PW6
yes.
says that the search was before the gazetted officer got there.
First day search. Lord,
But what does the gazetted officer say?
Gazetted officers also support, but the problem is.
No, does he say that he was present when the search went on? That is the main ground that you're taking.
Yes, my lord. So the
What
point.
does he say?
There are no, one second, my lord, there are.
You're not answering the question, counsel, so we have to draw the adverse inference
No, my lord, please.
that the answer is against you.
He says, I came later, the police officers had caught him. So one police officer says that.
Caught him is one thing, search of the person.
Search was by Tehsildar. He says, I came later. And
Yes,
then.
you're not answering the question. Show us the gazetted officer's testimony, please.
Page 67. I on 16th October, I was posted as Naib.
This is the Naib Tehsildar.
Yes.
The magistrate, the executive magistrate, who's the gazetted officer. Where is his deposition?
No, Lord, he has not been examined. He is.
That is what we asked you. You said he's been examined.
No, Lord, this Tehsildar, they say it is not before magistrate. It is between the.
Who is the gazetted officer?
This Tehsildar.
He's the gazetted officer.
Yes, my lord.
Show us the
yes.
FIR. Does it say that the Naib Tehsildar is the gazetted officer?
Lord, may kindly have page 27.
Yes.
My lord, public place, no CCTV, no photo, no independent witness. Brief circumstances of the case are as follows. I, Jalaluddin SI, along with E.H. Harichand and Amit Kumar. So there are 3 police officers, all of them giving different timelines, different statements. With vital government so-and-so for patrolling and informed Sunil, a resident of Punjabi Mohalla, Ballabgarh, for involving in drug trafficking.
67, the Naib Tehsildar says that the search was after he got there.
Yes, your lordship may kindly have.
And where is the question of you saying that the executive officer was not there when the search was conducted?
Initially, it was by the police.
And you also have past antecedents.
But there no antecedent. He was a minor thief. So he had some, was acquitted in and bail in other matters for 4 years. And glaring contradictions. One says that there were 5-6 people.
The trial court to consider whether you are entitled to bail at this stage when it is admittedly a commercial quantity is the issue. And especially when you have 6 antecedents.
Yes. No, there are no 6 antecedents. Please have the custody certificate. But all police officers are making completely contradictory on the timelines on whether one says 5-6 people were there, they all ran away. One says there was nobody there. One says some video was taken. The other says no video was taken, no CCTV was recovered. And independent witnesses, nothing. And timelines are also not matching.
72.
Yes, my lord. Custody certificate. There is one custody certificate at the very end. That gives a list of the other matters. My lord, page 95.
So you have several cases to your credit.
Yes. So that is why the police is framing me. Because he had some.
Seem to have progressed from stage to stage.
No, this is a case where they are sitting in the police. They are sitting
from
in
379. You progress to Excise Act. Now from Excise Act to NDPS.
So, Malad, may kindly see the glaring contradiction, page 87.
Section 37 conditions are
not
met.
because.
There is a question of believing you that you would, trusting that you would not go back to this kind of
There
activity.
is no antecedent or
You have promoted yourself from stage to stage, from theft to excise to NDPS.
Yeah,
So you can't give that benefit of doubt.
But 37, two answers. 37 is not made out for the simple reason that the sampling has to be done from each sample. So, and then you have
That is again a different issue.
You don't do the sampling.
The quantity found is in excess of the commercial quantity.
There are several judgments. People have been acquitted.
No good ground in reason to interfere with the
one
asked by the
one submission. Kindly see.
Especially petitions.
The state is taking multiple adjournments.
Sorry, comes.
When the
Next matter, please.
6 out of
Next matter.
18 witnesses.
We've already passed.
18 then your lordship may direct speedy trial because the state is taking multiple adjournments before the trial court. I have taken 0. And 4 years have passed and not even 1/3 trial is complete.
At this stage, we cannot do the same. Next matter.
Lord, may I renew my prayer for bail after some time before the trial court, your lordship?
Just make one observation. The trial court shall endeavor. However, keeping in mind the period of incarceration suffered by the petitioner, we would request the trial court to expeditiously conclude the trial. The petitioner is at liberty to renew his request for bail in the event the trial is not concluded within 1 year.
Grateful, deeply grateful. His lordships.
16.
He's undergone 2 years and 3 months. That's all along.
Honorable on 23rd September, service shall be effective by all means.
I'm grateful.
Item 17.
Don't say 23rd, 24th September.
May I
17.
Trying to live on another judgment.
What? Thought question, if High Court vacation period is excluded.
No, where is the question?
Even then.
It is beyond time,
My
clearly
90
beyond.
days period will expire on 30th of July. Then
Not
further 30
15th of June 24, it expired. You filed it on 7th August 34. 34, there's no question. 37, Bose brothers, even there, flexible. But 34 is cast in stone. No question. We find no ground. Delay control, we find no ground. We don't have to interfere with the improved judgment passed by the High Court. Especially petitions accordingly dismissed.
18.
My lords, in connected matter.
So 367 days delay in the High Court. So you thought it's better to compound it. So 662 days delay in filing here. Where is the question? At some point, litigant is expected to have a quietus to litigation. The state can't say that our mills and God's mills grind very slowly. So we will wake up at our own convenience. Rip Van Winkle is our brother. So we will wake up whenever it suits us and file a case whenever it suits.
I fully agree.
We find no grounds to condone the inordinate delay of 662 days in the filing of the special leave petition.
30%.
Full stop, more so as
Proceed
the
against
High
all
Court
officers.
held against the petitioners on the ground of delay of 367 days in approaching it. Full stop. The condoned delay petition and in consequence the special leave petition are accordingly dismissed.
Item 19.
Condoned delay petitions. Refiling is also.
Similar matters.
This is with the.
Yes, madam. Allah have in fact issued notice on interim relief also. Allah, there is small delay in the filing.
Issue notice and tag with SLP diary number. It must have been numbered. No?
Yes.
SLP
23084 of 20.
2308. That's what the diary number.
230. Yes, diary
Check
number.
the number. Delay has been condoned, so it must have been numbered, but the office report also doesn't mention it.
Order also says diary number. Allah, there is
Issue
nothing
notice
in
on the SLP as well as the prayer for interim relief there.
Yes, ma'am.
Tag with so and so. Delay condoned.
Extremely grateful.
Item 20.
This also, SLP is pending against the full bench judgment.
Yes,
Issue notice, tag with specially petition number. Which one is it? 19/7. So, 50360 of 2020.
Lordship, the delay may find difficult.
Delay condoned.
Obliged.
Item 21.
My lord, notice is issued against the same order.
Yes.
I'm challenging the same order. I was the applicant.
Delay condoned. Issue notice. Returnable non. I don't give it. It might be good. No, issue notice and tag with SLP, civil appeal diary number. Is condoned. Civil appeal diary number. No diary. Civil appeal number 010285 of 2024.
Much of that.
Item 22.
I pray for the similar.
24, perhaps the SLP is against another order.
4380.
But the
Ascot has come up.
Mr. Rodgi, there's no clarity in the order of the High Court with regard to.
Let both matters be heard together.
No, Lord, I have a submission. When my matter came up, my matter is essentially not on the question of interest.
Your SLP is against the same order.
Yes, the lordship issued notice and asked me to deposit 50 crores as an additory measure to show my bona fides.
No, but what is the date of?
That is 14380.
Lord, 19th May, your lordship issued notice in my case. asking for a deposit of 50 crores.
14380.
Yes. So what has happened is this, my lord, which I wish to say. According to me, my lord, the other side should be more than happy. My lord, I have as against 62 crores paid 210 crores. The only issue is whether I should pay 30% interest or 15%.
We'll hear both the matters together.
But my lord, if they've got a order of 30 or 40% interest, why should they have?
I'll find out if I'm really happy or not.
My lord, I mean, you can't be a Shylock. My lord, the most recent judge says that you can't be a Shylock.
SLPC number 0143802025.
And I have since deposited my lord the 50.
And the High Court says in paragraph 55, they can probably cite these proceedings over any. I think nothing should be done. The meanwhile.
No, nothing. I'm already drowning. What will I do?
We don't know. We don't know.
Item 23.
23 SLP is also linked. Issue notice and tagged with SLP C number 17380 of 2025.
Which I'm paying for status.
Status quo. 10 years on date shall be maintained insofar as the petitioner's properties and the acquisition are concerned.
Item 24. What is it? 1034.
Issue notice.
I need to say something on that,
You are not on caveat though.
I'm not on KVA, but may I
Without
only
caveat,
clarify
you're
what
not
is
entitled to an audience, please.
My lord,
We are not granting any interim order at this.
because
So it's a 2022 judgment.
Implemented the order?
no, the problem is that the PSU, it has not verified their salary details, without which we cannot do anything.
Whatever you need to do it. You can't pass on the buck and say that we will not implement it because someone along the
That direction, that in that.
the lineup is not cooperating. That is
That direction to the employer, not to us.
Requested that they should work as one unit,
That direction.
because otherwise there's somewhere, these drivers and
also I must,
where will they go?
I must also clarify.
My lord,
Similar.
readings shall be
depending on the
completed in the
reports.
meanwhile. Before the next date, file your counter well in advance so that they can file their rejoinder
Great.
if they need to.
my lord, a specific date.
7th October.
Obliged.
Great.
25.
Please, my lords. The issue is,
We've entertained one matter.
yes, my,
Lay down the law, Mr. Arvind Datar has been asked to assist.
yes, my lords, that order is.
But
page
the
27.
earlier matter that Aberdare, we dismissed it.
There a review petition has been filed. with-
Where's the question of reviewing it? We've only entertained one matter because you are doing this regularly.
My lords.
So we wanted to lay down the law. It's not that we are going to interfere in your favor.
My lords.
Because we wanted to make the position clear so that these GST authorities don't stick to their stand and stop all kinds
Because
of.
there is a
Your
time
portal
bar.
is full of glitches.
Yes, my lords.
I can vouch for it myself because at the time that I had to pay GST on my lease rentals, fortunately I don't have any more lease rentals. But at the time that I did, the number of complications, I think I spent more time with my auditor
That was
trying
the
to find
thing
out.
of period, my lords.
But
When they-
now you say that nobody can correct.
My
Your
lords,
portal was full of difficulties.
my lords, in some cases, the portal was full of difficulties. In this case, the admitted position is that that accountant was not very competent. So therefore, the guidelines.
We are not going to
that we laid
entertain
down
this.
cover all
One
the
matter is
business
enough to
cases.
lay down the law. We don't need to entertain more.
My lords.
In the light of the judgment passed by this court in
Aberdare. My lords,
Aberdare is.
may I point out in Aberdare, a review petition has been filed and it is pending. The
Maybe
website.
pending, but we will
pending.
dismiss it. In Central Board of Indirect Taxes and Customs versus Messrs. Aberdare Technologies Private Limited and others, SLPC number 7903 of 2025. We find no grounds made out to entertain this specially petition. This is accordingly dismissed.
This is a case of a resolution professional. What has happened is this,
Challenge the validity of the provisions.
I will tell you what's the reason.
There is a question of granting you a stay straight away. No,
There are two provisions. What has happened is this, without reference to papers, let me explain. I was a resolution professional in case A. I the COC accepted the resolution plan of Milord, an individual. He made a revision of that plan, 3 revisions, which are allowed by COC. By the time the revisions were effected, he was declared as a defaulter under 29A. So question arises, Milord, whether the original plan is the plan to be seen or revised.
Show cause notice, Mr. Rohit, given.
Now, Milord, the problem is that the effect of the show cause notice is that I am debarred.
That is because of the provision which you challenge.
So therefore, Milord, just look at this.
Once a provision is challenged, there is a presumption attaching to a provision's validity.
On a professional, Milord, I can't
respond to the show cause notice. We are not going to grant you stay of the show.
No, may I then, Milord, make a submission? Could a lordship request the High Court to decide it, Milord? It will affect every individual.
Sorry.
The High Court has refused it. Stay, Milord. Let the writ be heard.
I find no good grounds in existence.
I will withdraw it, Milord, subject to your lordship may make an observation.
At this stage, nothing. We can't manage the board of the High
No,
Court.
I am only saying expeditiously, Milord, if it is possible.
We, having argued for some time, then senior counsel appearing for the petitioner seeks permission to withdraw the specially petition permission. Especially petitions according to dismissed as withdrawn.
Please, Lordship. 27. Lordship, very unfortunate daughter.
Two daughters spoke against him.
Lordship, I want to bring.
In fact, the High Court ought to have clarified
I am not
what
on
it
marriage,
meant
Lordship.
by the life imprisonment sentence.
I am not on marriage.
Section 6 POCSO
Lord,
conviction means at least 20 years or life imprisonment for the natural life of the accused. The High Court doesn't say that, but hopefully they understand it that way.
I'm not.
Two daughters, not one.
The order has.
What kind of depraved person is this? Less said, the better.
Yes.
We have dismissed.
Yes, your Lordship.
And we have enhanced the compensation.
Yes, your Lordship. Regarding the compensation.
Petitioner. But not the same judgment. Stage was the earlier SLP? Bail, is it?
No, not bail, my lord. It's an SLP stage, my lord. After the conviction.
After the conviction, you filed one. Now again, you file another one.
No, my lord. This is another case.
Two. I see. The other daughter.
Daughters. Yes.
Other daughter.
My lord, I want to bring your lordship notice regarding this, the earlier order of this matter.
What does it say?
This says with regard to the compensation, your lordship.
We have enhanced the compensation.
Yes, your lordship.
So you want the compensation to?
No, my lord, not myself, but it is my duty as a counsel to bring this notice to your lordship. Para 14 and 15, your lordship.
The very same judgment.
Yes, your lordship.
In the light of the fact that the very same judgment was tested before this court in SLP Criminal Diary number 33114 of 2025, which resulted in the sentence being confirmed, but with enhancement of the compensation payable, we are inclined to adopt the same procedure in this specially petition also. The specially petition is according
Para 14 and 15.
Same person. Who's the same? The victim is dismissed. However, dismissed or disposed of? Disposed of, confirming the life imprisonment, sentence of life imprisonment imposed upon the petitioner, which would mean till the end of the natural life of the petitioner, but with the further direction that he would deposit a sum of rupees 10,50,000. This is for the state, is it? Who has to deposit this money?
The state of Himachal Pradesh.
No. Well, what did I say?
It would deposit sum of rupees 10.
With the direction was
Confirming sentence, life imprisonment imposed upon the petitioner, which would mean till the end of
the natural life of the petitioner.
But with the further direction that
the state of Himachal Pradesh shall deposit a sum of rupees 10,50,000 to be paid as compensation to the victim as per the scheme framed by it. out of the said sum, rupees 7 lakh shall be placed in a fixed deposit in a nationalized bank for a period of 5 years in the name of the victim, and she would be entitled to withdraw the interest thereon with quarterly rests. The balance 3,50,000 shall be paid to her directly by transferring the said amount into her bank account. Her bank account details shall be furnished by her. The bank account details shall be furnished by her to the member secretary, Himachal Pradesh State Legal Services Authority. In this regard, on maturity of the fixed deposit, the proceeds thereof shall be transferred to her account, and this process also shall be monitored by the Himachal Pradesh State Legal Services Authority. The specially petition is disposed of with the aforesaid directions.
The punishment was life imprisonment, simple without.
It can't be simple. That is what we said. Section 6 POCSO conviction means a minimum of 20 years, but may extend to the natural life of the accused, of the convict. It can't be 14 years. There's no question of it.
Item 20, it is a matter where the basic ingredients, the essential ingredients are not even pleaded.
The only point you raised before the High Court was compliance with section 141. Now you are raising new grounds.
No, but then my 482 petition clearly raised all that.
If you do not argue those points and leave it at that,
May I
then you can't urge those grounds without urging them before the High Court.
I appreciate one.
Before us directly.
May I point out one? Look, what is the transaction? I am buying paddy and rice from this fund. This month.
Yes.
I buy paddy and rice. I pay 30 odd lakhs.
There's no proof of that.
No, so
no proof of payment.
No, the question is,
it's a business transaction. You won't have paid it in cash.
No, it's been sent by RTGS.
There's no proof of it though. You have not produced a bank account statement, nothing.
One submission. When I get a round figure, I give him a round figure of 40 lakhs.
Definitely not a
He
case.
does not even say in his
not a case for quashing counsel, sorry. We find no good ground.
May I show the petition
itself? Judgment passed by the High Court, especially petition is accordingly dismissed. Sorry, you face the trial. If you have valid grounds, raise them there.
Item 29.
We have already dismissed the SLP insofar as filed by Ambika Soni is concerned,
because there was an allegation. The roles.
There's no question of distinguishing between you and Ambika Soni, because the High Court already did the task of distinguishing between the accused. Both of them have been given.
There was a specific allegation against Ambika Soni.
There's no question of distinguishing between you.
Exhortation, my lord.
Sorry, delay condone.
No,
we find no good ground and reason to interfere with the impugned judgment passed by the High Court, especially.
As far as 313 is concerned, my lord, the material evidence was not put.
Ambika Soni and you, other than sharing a surname, in the same boat. No question. Sorry.
No, the statutory appeal by the suspended promoter. The three contentions which have been taken out are about the Material Illegal Act.
We have already dismissed the other SLP.
The other SLPs did not touch upon the subject questions. For
all the issues that you raised have been dealt with by the NCLAT and validly.
No,
valuation of assets, promoters' assets, PMPENDING attached properties, resolution plan after the CIRP expiry. Everything. And it is for the PMLA to object to it.
No, insofar as the money.
If the PMLA has no difficulty with it, there's no question of.
I am agreed. I am agreed by
if the ED has no issue with it, then there's no question.
It's not the ED alone.
It's not for you to hold a wakalat on their.
Not on their behalf. I would be aggrieved because the property which is said to be vested in the Maharashtra government for defraying the dues of the depositors have not been.
It is for the Maharashtra government.
But can you see section 38 here for the present?
Sorry, Mr.
Lords, I am for the caveator. I represent 10,000 of depositor investors. Please hear me out. I am on caveat, my lords.
You are on caveat?
Yes.
To support him?
Yes, my lords.
No, sorry. You can't file a caveat and say that I'm supporting the petition. The whole point of a caveat is lost.
Just thought that I used to bring to you.
Caveat is filed to be given a hearing before an interim order is passed against you.
Exactly.
Therefore, there's no question of granting an interim order against you because you are supporting the petition.
Agree with my lord.
Sorry.
Here is
We
a
find no
thought that needs to be
good
brought
grounds.
to attention.
It's 32
My lord,
days refiling condone. We find no good grounds and reason.
My lord, the fraud as
good
serious
ground and reason
as
to
the
interfere
past
with the interim
expressions of
judgment
that
dated
judicial
1/7,
process.
2024 passed by the NCLAT. The civil appeal is accordingly.
This is very serious.
Sorry, your
My lord, just-
understanding of a caveat 148 itself is erroneous. So if you're starting from a wrong foundation,
option I had
no question of even allowing you to open your mouth. Sorry.
My lord, I
Sorry.
agree with
There
you.
is a delay.
Fraud.
Sorry.
There is a delay of 231 days in filing of the appeal.
202 days delay in refiling.
Filed on the 45th day.
Refiling,
On the
of course,
45th day, they filed without annexures.
without annexures.
Without annexures.
My lord,
Delay in refiling condone, but we are
but
discussing
the
the.
fraud, my lord, allow me 2 minutes, my lord.
Sorry, counsel, we don't have time to hear a counsel who is not even understanding what the meaning of a caveat is.
One, I'm requesting for a passable learned SG is leading us in this matter. My lord, sir.
We only need to know what you asked the.
Yes, my lord, sir. Learned SG, my lord, sir. We have.
Can't you just give us that information? If you say that you gave the wrong information to the CSFL, then we will give the right information and ask the CSFL to give us a report.
Yes, my lord. My lord, learned SG is leading us. My lord, sir, kindly pass. That's.
You're not allowed, Mr. Ramesh, is it not?
Yes.
You're not allowed to open your mouth also.
I am allowed to, my lord, sir.
All help you. I can't help you. This technical glitch is completely against you. There's no getting over it. We find that the petitioner,
Yes, I have been.
who appears as a party in person, filed the special leave petition, assailing the order dated 15/1/2020, dismissing his review petition without independently challenging the main order dated 4/7/2024, passed against him. On this short ground, this special leave petition deserves to be and is accordingly dismissed.
Well, as in item 33, Malats, apart from there is a serious violation of section 1104 to give a opportunity of hearing before the Tehsildar upon the remand order, he did not give. There is a serious wrong finding of fact.
But that's not a title suit. But you've not filed a copy of the judgment dated 21/12/2005. The judgment has not been filed.
We have filed the appeal copy, Malats.
And what is his application for substitution now?
What has happened, Malats? Mahila Ramkali died after the High Court order, Malats. That's why their legal heirs have been on record.
Very good. Application for substitution order. Permission to file special petition granted. Amended memo of parties, first that and then substitution petition. Amended memo of parties shall be filed within 2 weeks. Issue notice.
The status to be maintained, Malats.
Issue notice, return to law.
Unless there is a refind.
14th October. Copy of the judgment dated 21/12/2025, sorry, 2005, passed by the trial court shall be placed on record by the next date of hearing. In the meanwhile, status quo, date as on today, in respect of the purpose in question shall be maintained.
Delay may be continued.
Delay in refiling.
Item 34.
My lord is requesting a short pass over.
This is section 52A. Would it not be covered by that Bharat HON'BLE's judgment?
My lord, senior.
Have you examined it?
My lord, senior counsel Nagamuthu sir will be arguing.
So.
May
kindly pass over item 35.
35 also.
36.
Quickly, the lordship. It's a very, very broad, peculiar case, which will not be.
Look at your prayers in the writ petition.
In fact, that was exactly.
These kind of prayers, how can they be entertained in a writ petition?
Can I just explain, bro? My prayer and my gravamen was not that the FIR is not.
That of course is a mistake by the High Court. But apart from that, in a writ petition, you want all kinds of prayers with regard to
Can you only see one document?
adequate protection so that you can rebuild a wall and then conduct a business.
And I am the only Sikh family in that area.
These kind of disputed issues cannot be resolved in a writ
Can I
petition.
just raise one issue? Can we have the second volume for a minute? Look at the high-handedness during the pendency.
Whatever it is, not a fit case for a writ petition.
During the pendency of the case,
we can find no error on the part of the High Court saying this is not a fit case.
Can I say one thing? At least ask the High Court to decide, because this was my prayer, please protect me. And during the pendency.
You can't bark up the wrong tree and then say, please protect me.
No, that's right.
You need to avail the appropriate remedy and then seek relief. You can't file a writ petition for issues which are not to be addressed by way of a writ petition and then say
there might be an overzealousness as far as the prayer is concerned.
We find no good ground in
Not only one
with the impugned
Not
judgment
only
passed by
one
the High Court, the specially petitions accordingly dismissed.
Can I go back and raise that issue before the High Court?
Go before the appropriate forum. The High Court is not a forum.
Deciding that. High Court records in the order that the FIR
Not
is
for a
registered.
writ petition.
No, the FIR is
That
registered.
issue is already over. Charge sheet is already filed. There is a question of
And
investigating.
charge sheet also on the sections, serious sections of outraging,
Sorry, Counsel.
37.
Can I withdraw this?
Very well. Having argued for some time, then senior counsel for the petitioner seeks permission for the usual order. 37.
I beg to appeal.
Concurrent finding.
Lordship sees the 14/11/22.
Concurrent finding.
You are claiming easementary by prescription. The other side, yes.
They are not claiming the easementary right at all. The Tehsildar's right to pass such an order is covered by the statute.
Only two things I wanted to say.
Even if there's no right of way existing, that is what the trial court also says. But there is no way existing. But the Tehsildar's right is protected. First appellate court confirms it, second appellate.
Two things I wanted to say. Only two things.
Nothing.
Two things.
And this has been continuing since how long? 2016 onwards.
But please have page 86.
Sorry.
One argument.
We are not going to upset something that has been happening since 2016.
Before the merit, please have page 86 and then only one sentence I will say on merit. Page 86, Lordship says.
Yes.
14/11/22 order of the Honorable High Court, Lord.
Yes.
It says issue notice returnable within 3 weeks on the following substantial questions of law.
This the High Court, the trial court held in your favor that there was no existing. Come to para 6 of page 5. Section 143 of the Land Revenue Code confers powers on the Tehsildar to decide claims holding agricultural lands to claim right of way through boundaries of survey numbers. There, once that provision is there, Tehsildar has passed an order, all courts have held against you.
Only two sentences. I have not been able to complete two sentences. I am only praying for.
You already showed us page 86. What more?
One, Lord. Now please see the impugned order.
Yes.
Lordship sees, Lord, after some discussion, towards the end, Lordship will find at page 9.
Yes.
Para 14, Lord, the concluding sentence. In that view of the matter, in my opinion, no substantial question of law arises. Now, what the Honorable High Court has overlooked is that there were already substantial questions of law framed not for adjudication. That is one.
Those questions of law are found to be bereft of foundation.
Now on merit.
Sorry.
The second sentence is on merit.
Now we've heard you now.
Passage has been
Find no grounds to interfere with the impugned judgment passed by the High Court, especially petitioners according to this.
Good. Passage has been given from within my field.
That's the boundary.
From within my field.
Boundary, those bunds will be there, cart track on the bund. Nobody can claim that it is within my field.
They went
The
into
boundary, the bund which is there,
Yeah.
we have also seen fields.
No, Lordship,
So
sir, right.
don't assume that you can't just claim that the bund is also mine.
That's only a method to trouble me and encroach upon. That's all.
Sorry,
Thank you, Lordship.
nothing.
Get it clear.
Yes, to go by what is that?
By the trial court as well as by the.
There's a video of a dying declaration. You've only been asked to face trial. Your name was there. in the FIR.
I'll have to go behind bars as 302.
You were named in the FIR.
I'm named in the.
And the police are very benevolent towards you.
May I just.
Charge sheet, supplementary charge sheet, not named.
May I just explain why?
There's a dying declaration.
It's not a dying
Whether it will stand up eventually or not is a different issue. But at least sufficient to call you before the court.
Your Lordship, just allow me to explain what happened in the police. The police took the phone into possession from the other accused.
All that.
There was nothing traced.
Hell, Mr. Balra, there's no.
Nothing traced. Nothing traced.
At this stage, we can't hold a mini trial.
No, Lord. The question
Is this at least a fit case where you should be summoned under 390?
Not emotionally,
That
yes.
is 358
Yes,
TNSS.
emotionally, yes.
Not only emotionally, MO1 clearly shows that your name was.
FIR.
That pen drive is not proved.
That
That
pen
is the
drive
right
will
one.
need to be
It's not
proved
been
in the
proved.
trial.
Whether admissible or not.
All that will come in the trial.
Then you also leave that question open. High Court should have examined that. High Court should have
We find
examined
no grounds to interfere with the impugned judgment passed by the High Court, especially petitioners accordingly dismissed.
Item 39.
Your Lordship, I am appearing for the state. Your Lordships, I am requesting a short accommodation. Mr. Dharmadhikari is leading us in this matter. He is not keeping with your Lordships.
Now, appeal now. So it's an appeal and the notice has already been ordered.
Yes.
So perhaps we'll grant leave, call for the records and give you a date for hearing.
Yeah, bail is a fit case, but anyway.
Granted. Registry shall requisition the trial court record and undertake translation of documents in vernacular, if any. E-copies of the trial court record should be furnished to the learned counsel appearing for the parties. List for hearing on
Bail may kindly be granted.
10th. We were in fact in two minds whether this was in fact a fit case, but because another bench has already granted, at least issued notice, we are giving you that benefit of doubt. No question of bail at this stage. You've been, two courts have held against you.
19 months they have answered.
10,
But the original
10,
record may kindly be sent to the.
10, 12, list on 10, 12.
The original record may be given.
We've already asked for e-copies will be furnished.
Grateful.
Yeah, please, Lord. But this is a case, Lord.
R2, 3 and 4 have been served, but anyone appearing for them?
Appeal for the complainant.
Yes. Do you need to get instructions or file a counter? Now he wants to perhaps settle it by paying you some monetary compensation.
18 years have gone by, Lord.
How much are you willing to offer?
I don't know that. It's all village people, Lord.
No, you tell us how much. You can't buy your liberty at.
I'm not saying so, Lord.
No, you need to pay for it now.
3 months.
How much are you willing to offer them?
That, Lord, so village, we have to instruction.
You also find out how much you are willing
Whatever
to accept to settle.
Whatever Lord says, will
And
happen.
counsel appearing for the respondents, for the petitioner, as well as respondents 2, 3, and 4. Petitioners, as well as respondent, and also, you say, as well as one. And also respondent numbers 2, 3, and 4 shall ascertain from their respective clients as to what should be the monetary compensation for settling the issue at this stage, given the length of time that has passed since the incident. List on 23rd September.
Item 41. Legally matter. Which is those issues on the last occasion where there had been gross inconsistency found. That is predecessor bench
I need some time to file counter. First, I okay this.
Do you
I have already
need
undergone
to, do you
10
need to
years.
file a counter though? It's a,
I understand my appeal in a way.
it's completed 10 years, is it? But 2018,
More than 10 years.
2018 judgment you're challenging now.
Look, this is a.
We'll grant leave and go to the same also. Leave granted.
Consider issuing
Leave granted.
suspension of sentence.
No, not at this stage. You come with delay and then you immediately expect release.
Look, this is a legal ignorance.
2018, he kept quiet till now.
Expedited.
Leave granted. The registry shall requisition the trial court records and undertake translation of documents in vernacular, if any. E-copies of the trial court record shall be furnished to the learned counsel for the parties. List for hearing on 17th. Last week will be December. 11th December.
Item for 42.
42 letters there.
I see.
Learned counsel appearing for respondents 2 and 3. Filed a letter seeking an adjournment to enable file a counter affidavit. The matters accordingly adjourned. Based on 28th October. Exemption from surrendering granted earlier shall stand extended.
Yes, sir.
43.
It was, notices were issued only limited to the sentence.
No doubt, but they are entitled to file a counter.
I'm not saying anything.
Learned counsel appearing for the state filed a letter seeking an adjournment to enable him to file a counter affidavit. Matters accordingly adjourned. Pleading shall be completed by the next date of hearing. List on 28th October.
Can I make a request? This is a legal aid matter. The only material which was provided to the council was the two impugned judgments, the trial court and the high court.
What more do you need? We're only on the issue of sentence, quantum of sentence.
Because that time also I felt that it is not an effective assistance to the court.
Quantum of sentence, what other documents?
That day I think assist the court on depositions. So if depositions.
Trial court shall requisition, sorry, the registry shall requisition the trial court records and furnish copies of the same to the learned counsel appearing for the parties.
Deeply.
Item 44, it's in 44, I'm entering appearance for the respondent matters using served on Friday itself. So matters will give me some time to.
You're appearing for the state. Oh, sorry, this is the state says appeal. Sorry. Learned counsel appearing for the respondent seeks some time to file a counter affidavit. You need to file a counter affidavit.
Yes, sir. And the document.
List on.
Which may give us.
Counter affidavit along with supporting documents. List on 28/10.
Item 45.
I'm actually correspondent number 2, my lord. And I'm praying for 4 weeks time for counter affidavit.
No, 4 weeks is convenient, my lords, because now what I'm praying for at the time when your lordships were pleased to issue the second FIR, which is clearly a malified exercise after registering the first. Some sort of protection may be granted to us in the second FIR now. When your lordships
will be subjected to arrest in relation to.
No, the High Court has said that they will comply with the 41A, etc. on those guidelines.
Why do you worry?
No, they should not make it in because the state will investigate tomorrow, lay the charge sheet, then this becomes infructuous now. The whole ground is the second FIR is not maintainable in view of the first FIR, which was registered 6 months before that.
Lord, I'll file my response, lordship.
You are appearing for?
I am appearing for complainant respondent.
Because I am appearing for.
You are for the state. Learned counsel appearing for the complainant respondent. And respondent number 2, as well as the state of Telangana, seek some time to file their respective counter affidavits. Needful shall be done well before the next date of hearing to enable the learned counsel for the petitioner to file his rejoinders, if any. List on.
At the side of the
Or the side of the arrested.
Because they,
4th November, in the meanwhile, investigation in relation to the second FIR may go on, but no final report shall be filed.
I'm obliged. I'm grateful. Grateful.
46.
46.
This is a legal aid matter. The case is entirely dependent on circumstantial evidence and reversal of burden of proof under
Bloodstained clothes are also there.
My lords,
And she is killed at 11 p.m. Husband and wife are alone in the house. How will you say 106 won't apply?
My lords, there is no evidence that puts the husband on the side of the crime. And regarding the bloodstains, my lord, the bloodstains that were found on accused body, the blood group wasn't matched. So the blood had disintegrated, my lord. So if my lords
This was ordered. Who appears for the state? You need some time to file your response to this.
Sir, Rajiki seeks some time to file counter.
File a counter. At this stage, perhaps not a case for leave. So you file your counter dealing with the issues that he's raised. Then counsel appearing for the state of Chhattisgarh seeks some time to file a counter. In that regard shall be done within 2 weeks. Rejoinder thereto, if any, may be filed within 1 week thereafter, based on 29 October.
47. Wait, please, Your Lord. This matter comes up after notice, my Lord. This is a case where, my Lord, under the Bangalore Development Authority Act.
Who appears against you?
Sorry, I appear in the first matter, my Lord.
I'm appearing in the second matter.
Yes.
Several matters tagged.
The division bench order, which is at page 104, that has attained finality. Is it?
Yes, my Lord.
Once that division bench order has attained finality, holding that the scheme has lapsed.
The whole scheme has lapsed.
Then no, because implemented. Lord, kindly just allow me to show something, Lord, at page number. If your Lordship will kindly come to page number 197.
Extent have you implemented this?
Lord, if Lordship will see page 197, Lord, in our additional affidavit filed before the High Court, and I want to show the scheme under the Act. Lord, what has been misinterpreted here, Lord, is the scheme, Lord. If your Lordship kindly see 197, paragraph 5. As per the statutory scheme under the so and so, state government issued the following 4 final notifications. Number 1, 1994, 974 Guntal. Number 2, 97, 327 Guntal. Number 3, 54, 99, 123 Guntal. And 7, 10, 92 acres. Now over the page. As per the record, the following is the breakup of the land status covered by the final notification. Lands handed over to the engineering section 376 acres. Land utilized by BDA for formation of layout 201 acres. Government land not handed over 145 acres. Land denotified by the state.
No, but the actual implementation, where is it?
That those of the first two are the implementation under the scheme.
Handed over to engineering section.
No, for the purpose,
but the actual layout, laying of roads, sites,
the engineering section does that part also.
Where is it though?
Sorry, Milord.
We can't just accept your statement. You'll have to show us
an old
of the actual
then let me file a fresh affidavit. This is an old affidavit filed before the High Court. But I'm on a question of law.
I'm not arguing.
My friend
of the learned single judge's order records it.
Which
Para 85 Manot is at page 289. Out of 1,009 acres, 100 acres is implemented. Malots 289 para 85 Malots. With the Lordship's leave, I read 3 lines. Malots, by no stretch of imagination, the site was also originally contemplated to the extent of 1009 acres of land, and implementation is left with far less extent of 123 acres, 0.29 guntals. This is what Malots happened.
scheme is
If I
not-
may, and kindly see further, my lord. Even assuming that the entire extent of lands the schemes ought to be implemented, such implement is definitely no substantial implementation. And this position has not changed, my lord, till date.
With all due respect,
Ranjit Kumar,
please.
if this judge has granted the relief,
Yes, my lord.
that is something very, very surprising.
I don't want to make any.
Going by my brother's knowledge of that court,
Please, Lord.
perhaps,
But I want to.
perhaps
I know your colleagues at the bar,
Please, Lord.
same chamber,
Please.
and then we have shared the bench.
Please, Lord. But I want to say two things.
Land acquisition
If
of
my
land.
friend doesn't mind, two things that I need to.
Even otherwise, in a corrected matter, it has reached finality.
No, we have filed.
the other division bench judgments have attained finality.
That is where I am joining issue. We got two of the matters. One, because it was 2000 delay, it is only dismissed on the ground of delay. And another matter, the court found that there was no possession taken. But if your lordship sees page 300 and page 383, my lord. Page 383. In the other matter, which was noted by the High Court,
Yes.
my lord, which is dated. This order of your lordships of 12/10/2022.
Yes.
In this was the order by lot of 16/8/2018 at 384. If your lordship see the last para, the respondents are subsequent purchasers. Leave granted, interim orders made absolute at 384.
This is in relation to which judgment?
This is, my lord, in relation to the 2018 judgment. 16/8/18. Now, all of these persons, my lord, here.
To that extent, you are correct. All the petitioners were
are
subsequent.
subsequent
Purchasers. No,
But
but if the scheme goes, it makes no difference
No,
whether
the
they are
question-
originally
not-
landowners or subsequent.
With all due respect, not that is where I want to show the scheme that the scheme has not lapsed and could not have lapsed.
Let us
And
see
that
what
is
the
scheme.
earlier division bench said, page 106.
My lord, the K. Swami, my lord, Justice K. Swami, as his lordship was, my lord, that in the judgment in the Karnataka High Court, it is settled that till the time I get possession, 5 years will start from there. The 5 years under section 27.
Let's come to page 106.
Yes, my lord. I've got 106.
It is also not in dispute. From there, kindly read.
That in the aforesaid appeal, the issue which arose for consideration before various division benches of this court was regard to the lapsing of scheme with the
The
admitted.
name of the scheme is JP Nagar 8th stage.
Yes.
Are we now concerned with the JP Nagar 8th
Yes,
stage
sir,
or no?
we are concerned with
Then
this.
there is a question.
No, I'm only saying, my lord, that the matters are also.
This division bench said that JP Nagar 8th
The matter
stage
is pending here, my lord, with all
lapsed.
respect. A matter is pending here.
Even otherwise, Mr. Ranjit Kumar, senior counsel, these are all purchase, small bits of land purchase.
It's not small.
And
not
what
area,
you
very
want to do, they have already done it. It's a residential site.
With all due respect,
Let them also.
I'm more concerned with
There's
that.
no question of again sitting
No,
in the
the
field
question-
of judgment.
For me, my lord, as an authority, the question of law is very important, which is what I want to emphasize. I have an important emphasis on the question of law, my lord. Whether the scheme lapses or after, my lord, the possession is handed over to me by the government, or whether it lapses because it runs for 5 years under the Act.
This judgment, which is referred to at page 106, is dated 14/9/2017.
Yes, my lord.
That judgment was tested before this court and the SLP was dismissed.
Only because, my lord, only because.
You can't have very
Because there the High Court found that the possession had been taken.
JP Nagar 8th stage, the scheme has lapsed.
And it can come to 379. What my lord observed, my lord, just now, I'm requesting your lordship to refer to
79.
379. The order starts at 375. At 379, kindly see the last paragraph 5.
Yes.
Having regard to such a finding of fact, we are of the opinion the Bangalore Development Authority failed to establish that the possession of the property was taken by them. We therefore do not find any error.
What is the date of this judgment?
This is
14/9/2017.
And against this, my lord, your lordship, 14 September.
Leave the possession aspect aside. The finding of the division bench was that this scheme has lapsed.
My lord, that is where
JP Nagar 8th stage scheme has
that is where I'm joining issue with all due respect.
But that judgment attained finality. You can't join issue on an issue which has already attained finality.
Everyone matters your lordship have granted leave, matters are pending here.
Not in relation to JP Nagar 8th stage.
I am therefore requesting, my lord.
Sorry, Mr. Ranjit.
No, if Please allow me to show, my
We find from the record.
I'm very sorry, my
By
lord.
judgment
I'm
date.
sorry to interrupt, my lord,
Please,
before your lordship.
hear the order, there
Before
are
your lordship,
something.
the order, my lord, I have a problem, my lord. Just allow me, my lord. Please, if you don't mind. The authority has many such schemes and many vast areas of land, my lord. And I'm sure, my lord, one of your lordship knows about the fact about what is under the act. And the judgment of the High Court, which has been holding the field, is that the lapsing happens only after the government gives possession to me. I don't take possession of the land till the government does everything under the Land Acquisition Act, my lord.
Yes, we know that section
So therefore,
27, section 27.
27, let me
run from the date of taking for that MB Ramchandra's case.
Yes, my lord. And 36, section 36 deals with that aspect, my lord. So therefore,
Come to page 105, not just the division bench judgment dated 14/9/2007,
Yes.
earlier division bench 20th June 2007. Before
that is pending here.
8 June
That is correct today. 20th June is pending before lordship in this matter.
That is the other matter.
In this very matter, it is there.
Which other matter?
45 petitions are here, my lord. That 20th June.
2017 is not this SL.
Yeah, not this SLP, but that is also here before your lordship.
Which one is that?
It is listed, my lord.
47.1 is that?
It's not that one.
Where are you saying?
Your notice and tag has happened, my lord.
8617.
Sorry,
8617, if your lordship.
we find from the record that.
My lord, I am so sorry, my lord. Your lordship may see the order of notice and tag.
And more particularly,
Very sorry, my lord.
the judgment dated 14/9/2017 categorically held that the scheme, that is JP Nagar, Roman 8 stage, had already lapsed. This judgment was tested before this court in SLP C number.
My lord, your lordship may clarify why it was not.
Number 28329 of 2019. And the same was dismissed in the light of the clear finding by the earlier division benches in this regard, which has now been followed by the division bench. We did the judgment in view, we find no grounds made out.
Lord, I am very sorry to say this, my lord. I'm sorry to repeat myself, my lord. I want to say something, my lord. When your lordship say that order of 14/9.
Facts of this case.
My lord, 14/9/2017.
We've also distinguished it by saying given the peculiar facts of this.
I'm your request, your lordship. My lord, your lordship, don't mind, my lord. I want to make a request, humble request, my lord. Your lordship, when it says, my lord, that that judgment of 14/9/17 did not say the scheme had lapsed. Oh, it only said, my lord, that possession has not been taken, and therefore we don't find any error. Kindly read that again at 379 bottom para 5. I would not have insisted.
We have said in the peculiar facts of this.
The peculiar facts, my lord, I quite see, but even then, my lord, your lordship order.
The acquisition stood lapsed is what it said.
If your lordship see,
you'll have to also look at the single judge's order.
The single judge's order has 4 paragraphs on lapsing, my lord.
Not single judge held both. There were 4 single judges. So before the division,
twice the proceedings stood lapsed is mentioned.
Not in this matter,
acquisition stood lapsed, proceedings stood lapsed insofar as it relates to the land of writ petition.
So therefore, this petitioner, that is what is why I'm emphasis on that. My lord is reading.
Property was sought to be acquired for formation of Jayaprakash Nagar, JP Nagar 8 stage layout, final notification. And thereafter it says the acquisition proceedings stood lapsed insofar as it relates.
I am insisting on one
thing. We are of the opinion failed to establish that possession of the property was taken by the.
May I insist on just two submissions if you lordship permit me? I'm so sorry, my lord, I am insisting.
No.
This one is the fact that before the division bench in this matter, what your lordships are reading at 105, 106, there were several single judges' judgments which had held both ways. So they were also in appeal and we were also in appeal. It was not a set of appeals before the division bench.
These are all by you. At page 105, the 3 appeals which are mentioned are all by the BDA.
No, those are. No, I'm not saying I'm the impugned judgment. Kindly come to the page 1. Page 1, my lord, I'm trying to show. It is not just my appeal before the division bench. It was appeal, my lord, if your lordship see page number.
There might have been other appeals also, but so
no,
far as the.
Where because single judge had held otherwise against the subsequent purchasers. question is, my lord, a three-judge bench of this court in
Locus of
2015.
the locus of a subsequent purchaser to challenge the acquisition, that position is settled.
So therefore,
But here it is not the challenge to the acquisition.
it
is because your scheme itself has lapsed, because you
2010,
failed to develop it
the writ petition,
after, what is that date which is given?
my lord, the writ petition
You come out with that other
kindly
notice,
see the prayer, my lord, of the writ petition, if you don't mind.
99.
Page 201, kindly come to.
After 5/4/1999, you had to develop it within 5 years. You
No,
failed
my
to
lord.
do it.
That is where I am joining. It can't be 5 years from 99. That is not the law. Because that is not the law and the scheme of the act.
That is how the High Courts have understood.
No, that's
And that judgment has attained.
No, therefore I want to show, my lord, therefore, your lordship, please allow me.
Ranjit, we are not able to.
Kindly see the prayer in the writ, my lord.
We allow those other judgments to attain finality.
With all due respect, no, my lord, we don't. We have came in all against all three before your lordships. Against all those three matters we came.
Which other one?
No, those three matters.
You lost so far as the 14/9.
No, one I lost because the High Court found that the possession of this petitioner has not been taken. Number one.
Is there a finding here that you have taken possession of their land?
My lord,
Is there any clear finding either by the single judge or by the division?
My lord,
that you have taken possession?
if your lordship see, my lord.
If you don't have the proof of having taken possession, then
I have the
it's
mazhar,
completely covered by-
my lord, for taking possession.
You had to demonstrate it before the single judge and thereafter before the division bench, not before us.
Page 186.
Not before us. If your proof was not found to be meeting the standard required by the single judge as well as the.
All due respect, why I am insisting is this, my lord. If a lordship is clear in the writ petition in 2010, it is subsequent.
We will also note that aspect. I will make a correction in the order that will not be.
Notification at 203.
That Shailendra. Which is this? Points out that at page 262, the learned single judge records that this so-called possession Mahajar, which you came up with, was sometime in 2010.
Yes.
And therefore, it could not be acted upon, being well beyond the 5-year period.
That is where the law is otherwise. The law is, my lord, that on the date I got possession from the government.
So that 2010, 1999 is the 5-4.
So sorry, the possession, the government.
Sorry, Mr. Ranjit, we have spent enough time.
Award is a.
We have spent enough time on it. Sorry.
Just to make the fact clear to your lordship.
Facts are quite clear.
No, award. I'm sorry, award is of 2010. The award under the Land Acquisition Act is in 2010.
Yeah.
That award is on record at page 177. So, my lord, if the award comes in the possession, then government, if the land vests in
Development had to be within 5 years.
5 years after I get possession. I don't get possession, my lord, till the award is made. That is the law, my lord.
You're basically running around in.
No, my lord, I can show that judgment. I can show that judgment which says.
There's nothing that you can do.
No, please allow me to show that judgment, my lord. Page 129.
Thank you, sir. Thank you.
Is any order required? Respondent 9 is dead in this. 47.
47.
Respondent 9 is dead and no LR is on record. Respondent 9. So is there any order required on?
In one, which is in the 47.1, is it? R9.
Yes.
But anyhow, because we are dismissing the matter, you don't.
We will grant it in other matters and it's pending and your lordship don't want to grant it with that.
In your matter, R9 has expired. LRs are not brought on record.
But anyhow, we are dismissing the matter, so it doesn't matter.
Can use to the benefit. That's all.
Item 40. Sir, please, would your lordship consider putting it for hearing? I have a list of dates to hand over. Whether this assignment, the lands were assigned land under the 77 Act. So whether that would mean that it's land, the landowners can still be protected because we had given notice to resume. So that's a simple issue which arises. Because I'll have to take your lordship's to facts for the assignment, the 77 Act, and how we have purported.
You want it to be taken up on.
Some non-miscellaneous dates are 3-4 pages.
You are heading for the response.
Yes,
Status quo is already.
Yes.
As this matter requires to be heard, listed on. List on 11th November.
Grateful. Obliged. I'm grateful to the.
The order has to be extended.
It's a status quo continues until it is a fixed date discussion. Sorry, there's some objection.
There's an completement application.
That can be taken up on the date because the for transaction wants to.
There are plots, but plot owners, who purchased in 1968.
Subsequent purchasers.
68 plot.
Subsequent purchases. Very well. So complete intervention, that they can be brought in. In IAN number 46126 of 2024 is allowed. Amended memo of party shall be filed by the newly implemented respondent within 2 weeks.
Lordship, please.
Very good.
49.
Yes.
Please, not item 47.
Those pleadings are complete. I have a note here for you.
Send the order, send the orders. Oh, just a taxi.
Can I make one request? And I think I'm joined by many of my colleagues. If your lordship should have a system in this particular court, that 5 by 5 or 10 by 10. We find it impossible.
You already twisted your leg.
Trying to get into court.
This courtroom is small, but the registry
10 by 10 or 5 by 5 can be.
The registry believes that we should burn the midnight oil. So they send more and more matters, even by way of the supplementary list, more matters.
Whole Sunday, whole Saturday, when we finished, it was more than 11 o'clock. Speaking for myself, I might be slow.
Not at all. No, I was just thinking, my lord, maybe if your lordship started a system that for this court, 10 cases in a row come into court. It might be more.
But we'll need someone to stand outside and monitor also.
There is already security there who checks it. So sure, we'll all follow it. Anyway,
at least on miscellaneous days, perhaps.
Yes.
In fact, my brother was already commenting on how the council are also inconvenienced because they all have to stand in large numbers, and you never come alone, you senior counsel. So you need to have your retinue with you. So that makes it more difficult.
Perhaps they don't trust me alone.
Now, item 49.
Yes, I have a note on my submissions and a list of dates for your lordships. Pleadings are complete. List of dates.
Order to continue. Yes.
List of dates are in.
This requires to be heard, Mr.
It has to be
Take it up on a non-miscellaneous day.
Very well. I'm not mistaken, last time also.
Any need to file a counter in this?
Pleadings are complete.
Pleadings are filed, they filed as joint. This matter requires to be heard for all. The service is not complete.
It's complete. It's complete to the best of my knowledge.
No.
It's not complete.
Perhaps three persons are not. Respondents 5, 6, and 7 are not served.
I don't have to I have to see that it's done by the next date. Whatever date your lordship said.
In respect of unserved respondent numbers 5, 6, and 7, well before the next date of hearing. List on 4th November.
My lord's please. My lord, I think interim orders to be extended.
Earlier interim order shall stand extended.
My lord's
next date of hearing.
In item number 50, I appear on behalf of the Union of India. They're seeking time 6 weeks to file a counter in this matter.
When counsel appearing for the.
Question of law, my lord.
He still needs to file a counter.
Have a stance here.
How will he make known his stand unless he files a counter? Notice is ordered for that purpose, is it not? You can't object to his asking for time to file a counter.
I just want to bring it to my lordship's attention that even before the High Court, Union of India, in spite of several opportunities, chose not to file a counter.
Very well. They choose to file a counter, so be it.
Your lordship, I appear for respondent 3. I also beg time to file a counter.
Very well. Learned
By
counsel
Council of
appearing for the
India.
Union of India and the learned counsel appearing for respondent number 3 seek some time to file their respective counter affidavits. Needful in that regard shall be done.
My lordship may
Within
further say that whosoever
3 weeks. Other respondents may also do so if they so choose.
Your lordship, the service is not complete, just to bring to your lordship's notice. Respondent 7 is in the office report shown as not served.
Filed well before the next date of hearing. Service shall be completed in relation to unserved respondent number 6.
6, your lordship. Obliged, your lordships.
So grateful.
By the said date. List on 28th of
will my lordship be pleased to fix this matter for an NMD, my lord, for this
28th of
28. Obliged.
I'm for the respondent, my lord.
Yes.
I'm for the respondent. May I request your lordship to direct the court to switch on the fans at this?
Fans are also off, is it? Why are the fans off? The AC is, even the AC here is ineffective because of the crowd.
At least the fan.
At least the fan should be on. Yes, you're right. I did not notice that they switched it off. Please ask them to switch on the fan.
Yes.
This matter also, Mr. Divan, would require some hearing, is it?
No, I have a point to make here because
A point to be made on a miscellaneous day or on a non-miscellaneous?
No, today. Despite your lordship's order of 4th of April 2025 and a statement made by other side's counsel, they are not cooperating.
No.
This is so unfair.
Appear before the RE.
So please just see the operative direction of 4th April 2025.
They're not appearing before the RE.
Let me read the statement. The learned senior counsel advocate appearing for respondent number 1 states that the witness along with records and data will appear before the Rajasthan Electricity Regulatory Commission on 6th May 2025.
Yes.
Now they don't come there with any records and data at all. They come there with a sheet of paper and with some tabulated statements which they hand over. So after that, and we see the next part. Notwithstanding the impugned order, the proceedings before RERC may continue but no final order.
Yes.
Now what RERC in a series of subsequent orders has found is that despite the summons, they are not coming and they are not producing the underlying documents at all, which is my first point. Second, they are then asking for time before the RERC in the most recent order, saying, oh, the matter is pending before the Supreme Court. Despite this, that the proceedings continue but no final order. So we'll argue this issue on the merits, but in the meanwhile, they must produce documents.
After we finish this.
You're appearing for R1.
I'm appearing for.
But why are you not cooperating?
I am cooperating.
Did you produce the records?
I produced the
not tabulated statements which you have made.
No,
the records.
My commercial information, and I'm not a regulated entity. Your lordship did not.
We've directed you to produce the records.
Did not specify which records. I produced my records to show what is the mining.
Record would mean the original, not a tabulated statement that you have made for the purpose of
into hundreds of books.
Whatever it is, that whatever is relevant according to you, which you need to produce, you need to produce the original.
RERC have jurisdiction over me. That is what they should.
Once we allowed the RERC to proceed with the hearings, you can't say that we will not cooperate with the hearing.
All my if I'm not a regulated entity, number one.
These aspects we will consider at a later date. In the meanwhile, if the RERC is permitted to continue with the hearings, you must cooperate.
Please allow me to say this. My commercial information.
When we passed this order, whoever appeared at that stage, who did not appear perhaps, whoever appeared did not say that this order should not be passed.
Your lordship did not say the commercial information. The commercial confidential information must be produced.
Records, we say. You're not producing the records.
I was appearing with the records.
Simple question, Mr. Chidambaram. Did you produce originals before the
I produced a statement.
Which you prepared for production?
Yes.
That is not a record.
Your lordship only abstract, not actual. I appear on behalf of RERC. Only an abstract, not actuals.
They produced the abstract.
Abstract.
Yes, they prepared.
Statements they prepared. We have also filed that undertaking the record of proceedings.
Records run into hundreds of documents.
Whatever it is for the RERC to look at it. You can't say that it is voluminous, therefore I can't carry it.
Lordship decides. Once your lordship decides.
That is contrary to the order, Mr. Chidambaram. Your client cannot change its stand depending on which senior counsel it has engaged. The senior counsel who appeared for your client on that day had no objection when we passed this order. This order was passed in the first court. I was there, and every order is passed by the High Court, by the Chief Justice, in clear terms which are audible to everyone in the court. So he heard these orders being passed. He had no objection to it. Merely because your client has changed the senior counsel,
no.
It doesn't mean that you change your stand, and we are expected to change our stand
to the case.
That doesn't happen.
All I'm saying is your lordship did not specify what
you are admitting to the fact that you did not produce the records. That clearly indicates that you are not acting in accordance with our direction. There ends
chartered accountants. Please see
You
the.
may direct them to comply with the order.
Only statement. No, this is a certificate. Milord, kindly see the paper book, page 9. Kindly see page 9 of the annexure 1.
Second page.
No, let me complete my submission. Please see page 9.
One moment. Let us see what order was passed by the RES.
There's an order of 20.
He says, I must produce all my costs. It is no, I'm not a regulated entity. Rajasthan High Court DB is in my favor. They are in appeal.
This order clearly indicates that you're not cooperating. You're not acting in conformity with what we have said.
That's your lordship.
Order after order. Okay,
It's your lordship to decide whether I've cooperated or complied.
This order clearly demonstrates it.
Please see page 9.
Your lordship will see the 8th July order.
Witness and record.
8th July 2025 order.
Not so merely a general.
Please see page 9 and the annexure.
So the statement that you filed of your average monthly mining expenses, you don't even support it with the supporting data and records.
See that the statement, my lord. The statement is before my lordship.
This is a very serious transfer pricing inquiry. Very serious.
Sham.
Where they want, yes, but they want the underlying documents. That's all that is to be summoned.
We show the document.
Which page do you want?
Page 9 of IA 187991. Please see the documents. Please see the documents and the annexures.
IA. You have it.
My lords, IA 187991.
18799.
9 and annexures, it's a chartered accountant certificate. The judgment in my favor of the Rajasthan division benches that the RERC has no jurisdiction. They are in appeal. They are entitled to argue their appeal. Now kindly see page 9. Pursuant to your request, may I read it? And the annexures show the entire data from my inception to the present day. There are several pages of annexures. He wants my account books, my commercial confidential information, every single invoice.
Every aspect that you mentioned in these tabulated statements,
yes. It's a chart.
It can't be accepted as your report. There must be supporting documents for that. Your record has to be examined.
Invoice has to be produced.
Of course, if it's a sum.
If you do not comply with the order that we have passed, we'll have to draw an adverse inference against you. That we will make clear. If you choose to abide by the order, abide by it. Otherwise, we can't hold a gun to your head, but we'll have to draw an adverse inference.
Your lordship may hear me for 5 minutes. What did your lordship want me to produce? Did your lordship, I ask your lordship respectfully, did your lordship's intend that I should produce every invoice?
Records and data mean originals. These are not originals. You just make a tabulated statement. These are not originals. Your records.
Hundreds of
records.
Hundreds of
That is for the RERC to break its head over. You can't say that I can't carry hundreds of books.
Absolutely sure. Your lordships did not
intend. The order dated 4/4/2025 passed by this court makes it clear that respondent number 1, who was represented by a learned senior counsel on that date, undertook
your lordship may specify
produce the witness along with the records and data before the Rajasthan Electricity Regulatory Commission on the stipulated date, that is 6/5/2025. Order dated 14/8/2025. Passed by the Rajasthan Electricity Regulatory Commission is placed before us, which demonstrates in unequivocal terms that respondent number 1 has not been abiding by the aforestated direction of this court. In the event, respondent number 1 fails to produce the original records and data that it wishes to place before the
That has been summoned.
which have been summoned. The original records and data which have been summoned by the Rajasthan Electricity Regulatory Commission.
But he wants every voucher. It's been truckloads for the last 15
One
years.
moment, Mr. Chidambaram.
Fails to produce original records and data
As was
which have been
summoned by the
summoned
summoned by the Rajasthan Electricity Regulatory
Where
Commission,
is the summons?
along with the witness.
Where's the summons?
On when is the next date fixed?
it has not because this person wanted to.
They've taken an exam.
Any
But
date?
what should they fix the date?
Kindly specify what records I should.
The records that they have asked for, you produce them.
Well, he wants every voucher, every.
Whatever they wish. You can't say that I will not cooperate while we are still of the matter.
Last 15 years, please see my
8th
difficulty.
September.
Grateful.
On 8th September.
And you're wrong.
The Rajasthan Electricity
No,
Regulatory.
8th September, it's simply not possible.
Very
to
well.
produce
15th September.
Vouchers and receipts.
15th September. 15th September, Mr. Chidambaram.
Yeah, very well. Well, that's a non-miscellaneous date.
Please hear me.
No, this is on the, before the RERs.
Okay, so 15th September. And you're
15th
wrong.
September, we'll take it up on this matter for hearing
Minutes.
on
My lord,
7th October.
Lord, may kindly hear me for 2 minutes.
We have already heard you, Mr. Chidambaram. Your client, on the face of it, is blowing hot and cold.
Please allow me.
We've already told you when the senior counsel who represented your client heard this order, he had no objection. Now, second thoughts on the part of your client, with a second counsel now, and a new standards sought to be taken. That is not happening.
Please allow me.
That is not happening.
Please allow me 2 minutes.
We will hear you on 7th October. In the meanwhile, you produce the records.
Please allow me on this order.
On the next date, we will hear you. You can't play around with the orders passed by this.
Your lordships intend to that I should produce a record.
Produce whatever it is.
Ledgers.
Engage a trolley, a van, a lorry, whatever is necessary, carry all the records
Every voucher,
and
every
place it
bill.
before them.
Number 1.
RERC is not someone whom you need to distrust, is it not? It's
No, RERC says he will share it with everybody. My commercial.
Where did you get it from that the RERC also put it in the
The
public
hearing
domain?
says everybody will be.
Are you planning to advertise it? Where is that?
That is what they.
Did the RERC say that whatever?
Can I just explain?
If it may refer to it in the order,
Yeah.
it will only refer to it in the order, and we've already stated the passing of the
Absolutely,
final
Lord.
order.
Yeah.
Where is the question?
Yeah, exactly. Lord should please.
No,
Next matter, Mr. Chidambaram, we have heard you.
no, I'll just tell you.
The only thing that the RERC can do is refer to it in its order, which we have already
That's what it
stated.
says. Please allow me to read the sentence. Registry is directed to provide the copy of the information submitted by Southwest to the respondents, stakeholders, and the petitioners also. Who is stakeholder? Everybody before the.
Which information? That's some other information. Record is to be given to the RERC. You are reading something.
This is the order, Milord. This is the order. Please see item 3. Registers directed to provide the copy of the information.
The order dated, mention this, the order dated 21/4/2023, passed by the RERC with regard to disclosure of details, would not cover the original records which would be produced by R1 before it.
Please add the original records.
Original records would be seen by them. That is, these tables which you have filed, these tabulated statements would perhaps be shared with them.
No. Your lordship may make it clear.
Yes, we've already said that the records are not to be shared. Where is the question? If you take a lorry load of records, the RERC
several lorry
hardly make copies and distribute it to every
lorry loads. I'll have to make copies and give it to the registry.
We've already said that the records are not to be shared with them.
No, practical difficulty. So 15 years records.
You already said engage a couple of lorries if it's necessary. Take it.
No, please give us more time. Please, Governor, give it more
You
time.
don't have to sift through your records to select. All your records you will take. They will break their head over it. Why are you concerned?
Please understand a mining company.
You obviously want to sift and select your records.
I don't want to select.
For that you need time.
It's a bit
If
tabulated.
you don't need to tabulate it. We are asking you to produce the records. Where is the question of tabulating it?
He's asking for a particular bill or a particular.
Then you search for it in the court. That's all. There's no question of your.
RERC works, my lord.
We have not said anything. You produce the records. That is all.
That is
all.
the RERC works.
Next matter,
Next
matter, Mr. Dambram. We've heard you long.
Here before the RERC, he is brusque, he is abrupt, and they.
We don't know about all that. You take it up with the authorities if you have an issue with who has been appointed.
No, your lordship may at least make it clear that the records will be kept only for the perusal.
That we've already said. It will not be shared. That's all. There ends the matter. There ends the matter, Mr. Chidambaram. We've heard you long enough.
Please repeat that.
We've said it, that the records to be, the order dated, whatever that date was,
21st April 2023.
April 23 will not extend and cover the records to be produced by ARGHYA. Next matter.
This is 6th of May, my lord. This order is 6th of May. Your lordship may mention that.
6th of May. There's no order of 6th of May.
There is an order at page 34. IA 174.
6th of May of 6th of
Your lordship.
2024.
No. IA 174750. There is a order of at page 34. Which
Your lordships, just on this particular point, 6th of May order is not talking about the records post that. It talks about the record which was already been submitted on 6th of May. And that is a chart and the submission which was already given to us. Your lordships.
Nothing more, Mr.
So that this order.
Nothing more.
65, item 3.
Nothing more, Mr. Chidambaram.
Your lordship mentioned this order also.
He's already said that that information is being given to them. What remains then?
No, it will be shared with the.
It is already shared.
No, it's not being
They have
shared.
filed it in the Supreme Court, your lordship. Same thing.
It's not being shared.
That is a tabulated statement. It's not part of your record.
The tabulated statement can be shared.
Item 52, please.
My lords, an opinion
You
on
filed
the
a
petition.
letter, bereavement in the family.
Yes, my lords.
The counsel for the respondent filed a letter seeking an adjournment on the ground of bereavement in the family. You said in the letter, advocate for the respondent. Is it the respondent or the petitioner?
Petitioner, my lords.
Why are you killing off someone in the respondent's advocate's family then?
Apologies.
Petitioner.
My lords, interim order with
Earlier interim order shall continue
much obliged.
to operate on the next date of hearing. Services to be completed perhaps?
It's completed, my lord.
Final reply.
Only one respondent?
Respondent number 5, we have received the call.
No, but the others are also served?
Yes, my lords, we have.
Office report 6, my lord.
Services complete? Yes, very good.
Much obliged.
Item 53.
My lordship, we are seeking 2 weeks time to file, to bring on record the legal
Lot of R1.
of respondent one.
Learn counsel for the petitioners, take some more time. You take necessary steps in relation to deceased respondent number 1. You filed a counter.
I have already filed, LRs were already on record before the Honorable High Court. They already need to file the amended memo party that was filed in the High Court.
They already parties before us.
No, my lordship, they were in before the High Court, my lordship.
You failed to implement.
Yes, we failed.
They were parties to the impugned order.
They were parties to the order, yes.
Then you went by the earlier cost title.
Yes, my lordship, there was a mistake. The synopsis was not correct. We'll just correct the synopsis.
Lordship, I placed the order.
Take necessary steps.
Yes.
You won't say LR petition, take necessary steps in relation to deceased respondent number 1. Yes.
Grateful, my lordship.
List on 28th of
28.
Item 54.
This was a suit for injunction.
What happened to the mediation before the
mediation failed, my lord.
Mediation
failed, my lord. My lord, the issue in this case is that this is a suit for infringement of a.
I had to file a counter affidavit, which we have
three main points in this case, my lord. First, my lord, this is a suit.
We have filed the counter affidavit this morning itself.
Oh.
The lordships can have it on board next week. If they don't want to file a rejoinder, have it next week.
My lord, I'm in some difficulty next week. Would your lordship take it up in the, my lord, would your lordship consider taking it up on a Tuesday?
Or non-miscellaneous.
Tuesday, my lord, 16th.
The difficulty is we have one non-miscellaneous day per week.
Lord, I
Makes
will,
it very, very difficult.
Lord, I will finish in 15 minutes by the watch.
So even if we do give you a date, Mr. Petitioner, then the matter goes to the bottom of the list, which means that your matter may not in all probability reach on that day.
Whatever is,
you will form part of the queue
sorry,
and slowly climb the ladder.
I understand.
So that you'll have to wait for your turn once you join the queue.
Whatever is convenient, my lord, whatever is convenient.
Then counsel for the respondents. All the respondents?
Yes.
States that the counter affidavit was filed today morning. Registry shall verify and place the same on record. Rejoinder thereto, if any,
no rejoinder,
may be filed, if any, may be filed by the next date of hearing. List on 14th October.
55 readings are complete.
Public Service Commission believes in being on a different page when compared to the Kerala government.
There was only one point here.
This is the second time that I'm coming.
But it's
I already made positive comments against you in the earlier round.
Just one point I'm saying. The only ground we took was that daring subject is not studied right. We did not have this
The
daring.
university says it's equivalent. The government says it's
Then not
equivalent.
right because
Then where is the question of you undertake recruitments for the government? And the government says we recognize this.
I
to
see
be
the point. Only one, he was ranked, should my lord feel like that. He was deleted from that rank list. So he'll just take his place or whatever, as per his mark.
So we'll dismiss this SLP. Whatever follows will follow.
Yes, that's right.
But you need to put your house in order, Mr. Nayak.
You go by the advice of the government.
We made enough comments in that earlier judgment. I was sitting with Justice Narasimha.
Yes, I know.
Then
I
what have
read it.
you've not
No, this is an
taken a leaf out of
It's an
that?
older case.
This is an older case.
Yes.
We find no ground made out to interfere with the improved judgment passed by the Kerala High Court, especially questions.
Right.
Article 56. 56 letters there. Then counsel for the respondent seeks some time to file a counter affidavit. Needful and that should be done within 4 weeks. When it has to come, wait till the order is pronounced at least. Shall be needful in that regard shall be done within 3 weeks. Rejoinder thereto, if any, may be filed within 2 weeks thereafter. List on 4th November. Interim order dated 18/7/2025 shall continue to operate till the next date of hearing.
Item 57.
Please, girls. Because your lordships were indulgent enough to give me an interim order. Despite that, what the state government is doing is, can we see from my IA, this may see annexure P48.
IA.
Which IA number?
Plus IA number
For the state in this.
198420.
Am I not?
198420.
Yes, please.
Which annexure?
Annexure P47.
Page
6 of that application. So, absolutely for a different context, I say that please give me extra time for implementation of the project, and I'm sending you the draft as per your scheme. I'm making those payments. In response, Lords, on next page,
citing your lordship's order, because may I just draw lordship's attention to the next page?
Yes.
Well, as the government writes to me and says, regarding the above subject, it is stated that SLP number so and so, the Honorable Supreme Court has passed the following order. Till the next date of hearing, status quo obtaining as on this date shall be maintained with regard to the properties of the petitioner. In view of the aforementioned order.
What about service? Someone is appearing.
My lords, I am appearing for the state.
Yes.
My lords, I have received this copy only on
Honorable Court has
Saturday.
not granted any stay on the demand notice.
Council.
My lords, firstly, this application has not been served on me and I've entered appearance only on Saturday. I'm requesting if I can put in a reply, my lords. I need to seek instructions in this matter.
But this kind of attitude on the part of your authorities on the last date.
My lords, I don't even have the application, my lords. I understand what's calling from my lords.
Leave your application.
Please, my lords.
That page, earlier we looked at one page, is not, what page was that? 237.
Please, my lords.
Have you got the SLP papers, madam?
Our committee's reports.
237. You already suffered an adverse order, and then you say
have this next week, my lords, because I don't have.
Take further necessary action in this matter in the light of the earlier decision of the Supreme Court, as if the Supreme Court gave you liberty to reopen the issue. That was never there. We in fact asked the council to produce
next
the
week,
order.
my lords,
After that, he said there's no such order which gave liberty to you to reopen the issue, and then you suddenly come up with this fresh demand, obviously for reasons that we cannot acknowledge in open court.
My lords, I'm only requesting if my lords can have this next week.
We will have it next week, but please examine this matter.
Very well, my
this
lords,
kind of attitude we will not take too kindly.
Very well, my lords.
So the council appearing for the state of Punjab seeks some time to file a reply. Notice they are again saying that they'll take some coercive action.
Because they are saying that, as far as my implementation of project is concerned,
Sir, you held it up.
They said we will not allow that because you have not paid as per the demand notice. Saying that there is no stay of the demand.
Next Monday we'll take it up. In the meanwhile, you find out in letters.
Very well, my lords.
Grateful words.
The Learned Council appearing for the state of Punjab seeks some time to.
Because my friend will file a reply to my IA
petition as well as.
I don't have the IA. My learned friend can serve it to me. I'll file a reply.
2025. A copy of the IA shall be supplied to the Learned Council for the state during the course of the day.
You file IAS without serving a copy.
It was
If she filed, entered appearance only in the morning.
My lords, I've entered appearance on Saturday, but the IA has not been served along with the papers.
Sometimes takes time.
We'll just serve her another copy.
Immediately.
Obliged, my lords.
Next Monday.
May it please, my lords.
Yes.
May it please, my lords. Lordships, in this matter, by the judgment which was uploaded. Yes, lordships. On 31st July, lordships had granted 8 weeks time, lordships. So lordships may see, if lordships, it may be listed in the last week of September. Lordships had directed.
Submitted by August 25.
No, lordships, the judgment is of 31st July, lordships. The judgment was uploaded on 31st July. Lordships, para 37, lordships have granted 8 weeks time. Lordships may list it after that.
For compliance with the judgment dated 14/7/2025 in terms of a report being filed by the Principal Home Secretary.
Lordships.
List on.
Well, Lords, I want to place certain additional documents. You want to keep liberty to file.
List on 6th October. Then counsel for the petitioner is also at liberty to file additional documents. Why additional documents at this stage?
There's a call history which I have extracted.
Sorry?
Call history which I have extracted.
What have you extracted?
Call history, Your Lordship.
Call history.
Yes. When I communicated to the SHO the order. I am correspondent number 1 in this.
They can serve as a copy, lordships. We will file it along with that.
Counsel for the petitioner is at liberty to file additional documents, if any, with advance copies thereof to the Learned Council for the state.
Grateful, lordships.
I am grateful.
Public contemners.
59, there are multiple orders of Delhi High Court. Inter
Yes,
because in 59, I've been marked the matter by legal aid. I've been marked the matter by legal aid.
Why legal aid?
I received a letter from legal aid.
We did not ask the legal aid to
Received the letter from legal
issue
aid.
was notice. Yes. Notice was issued and status is not even, there's no indication as to whether she's been served also.
No, there is an official letter.
Served, is it? 22nd August is the last. You have a later or what?
The office report saying 26th August.
I have a 22nd August or what?
Today is 25th.
22nd August OR says nothing about service.
24.
But you've been engaged by the legal aid.
I received a letter from the legal aid to ask
This matter?
Yes, ma'am. I filed my power in the morning. I request some time to file a counter.
Wait. You got in touch with this respond number one?
Yes, she's online.
Have you complied with the orders of?
Yes, Mullah. Yes,
Deposited the amount?
Disclose. She has been served.
No. Have you deposited the rent as ordered on 22/8/2022? Earlier it was said 100%. On 22/8/2022 it was modified and said.
That's for the respondent, not the petitioner.
Oh,
she has to. He's the land. She's the landlady.
I need instructions.
But
Because I
what
filed my
is
power
this?
today in the morning.
But every drop of the hat, you have ensured that the
Perhaps
courts
the lady approached the legal aid.
Yes, that is why they have been a letter to me saying that you are to be.
But we'll give you a short date. This is a clear case of abuse of process. Nothing short of it.
2 weeks, my lord.
No 2 weeks, 1 week.
Fair enough.
When counsel appearing on behalf of respondent number one, there's only one respondent. On behalf of the respondent, states that he was instructed to appear only to the morning by the Legal Services Committee and seeks time to file a reply. Needful shall be done within 3 days. Adjourned the date, if any, may be filed within 2 days thereafter. List on next Monday's.
May I make a short request? Can it be on next Friday? On Monday, there is some religious.
Monday, please.
I'm in a personal difficulty on Monday, so I'm all right and requesting for Friday, next Friday.
Ask your colleague to appear, sir. You have a very bad case.
I understand, but on Monday I have a personal difficulty.
Ask one of your colleagues to.
Because the difficulty is since legal aid has marked it to me, I'll have to be
Your office colleague. He can represent.
Fourth.
My lords, obligation.
Petitioner's file counter, my lord, in page 5, they have admitted my case actually, that yes, I'm only see page.
Is this you're appearing for whom?
I am appearing for the School Service Commission.
Is this the only writ petition which was filed before the judgment? Are there others who have questioned?
No, others have not.
The fact that they've been included in the tainted list?
No, they have not yet filed it.
This lady filed a writ petition prior to the passing of the judgment itself.
Yes.
Are there others who have also done that? Does any of you know, Mr. Vivedi?
No.
Did anybody else file a similar writ petition questioning their inclusion in the tainted list?
Some petitions have been filed, but
those petitions will have to be dealt with on merits. We have not gone into the issue of whether the tainting itself is valid or not. If someone has raised the issue that my name ought not to have been included in the tainted list, these are the reasons for that. The High Court has to adjudicate upon that. So the High Court can't say that because the division bench held cancelled the selection and the Supreme Court affirmed it, this writ petition becomes infructuous. That doesn't follow.
In this matter, High Court didn't say that. Original matter.
The High Court refuses to entertain the writ petition on that ground.
That's right.
That won't follow. The High Court has to adjudicate this writ petition.
Who doesn't?
Who is R4? R4 is the CBI.
Yes.
CBI is not an SPI.
Not required.
So we'll dispose of this then. Direct the High Court to adjudicate the matter.
Written exam is there, my lord. There is very short
we can't step into the shoes of the High Court and decide the
I could
request.
release the matter, my lord, only, and when there is
You
admitted
press
case,
for interim relief then.
they have admitted in the counter.
No, by virtue of today's order, you go and press the matter before the. That's all.
Very well, my lord.
The perusal of the leave granted, perusal of the interim impugned order reflects that the High Court was of the opinion that the writ petition filed by the petitioner, by the appellant, did not warrant consideration on merits owing to the judgment of this court in Civil Appeal number 4805 of 2025 and batch titled State of West Bengal. And batch, don't say this. Civil Appeal number 4805 of 2025 titled State of West Bengal versus Baisakhi Bhattacharya within brackets Chatterjee and others and batch. Full stop. However, we find that the writ petition in question was filed long before the adjudication of the matter by the division bench of the High Court, which came to be confirmed by this court in the aforestated civil appeals. Full stop. The grievance of the petitioner as to whether or not she was liable to be treated as a tainted candidate was never adjudicated by this court, by the division bench or by this court. The said issue, therefore, remains open for adjudication in the writ petition filed by her, which is still pending before the High Court. We accordingly dispose of the writ petition, permitting the petitioner to pursue her writ petition before the High Court. It is also left open to her to seek appropriate interim relief therein as deemed appropriate. Don't say as deemed appropriate. Therein. The specially petition, the appeal is accordingly allowed in the aforestated terms.
7th is the exam, 7th of December.
You need to approach the High Court, file an IA, seek for the interim relief.
I'm obliged.
61. Yeah, please.
Yes.
We have entered appearance in the matter, but file a short counter. Actually, tell them we come.
Restaurant has already filed.
Here, you filed the letter and described yourself as an advocate for the petition.
Of course.
Learned counsel for the respondent. Seek some time to file a counter affidavit. Needful in that regard shall be done within 3 weeks.
Anything can happen.
There too, if any, may be filed within 1 week. List on 14th October.
Much obliged.
Yes. Doctor's appointment. Can't you at least adjust your doctor's appointment to suit?
I apologize.
And especially after you secure an interim order.
My lord.
You secure an interim order, then you get a doctor's appointment on the date that the matter is coming up. You are appearing for the response.
Response number 1. Well, I am everything, every procedure according to this one order, my lord. Can you
Sorry?
This honorable court order?
What happened?
And
What is this order?
service is also not complete.
Service is not.
Kindly come to the page number 12, my lord.
Well.
12. The
Yes.
first where in reference of the order of this court, 29th September 2009, by this court directed that henceforth no unauthorized construction shall be carried out or permitted in the name of the temple, church, masjid or gurdwara, etc. on public street, public park or other places. But again come to the page number 13. 13, the second para in the bottom middle.
Yes.
To ensure the implementation of direction issued by this court, consensus have been arrived at the bar, and in our opinion, rightly, that the implementation of the order should be supervised by the concerned High Court. We constantly remit the above matter to the respective High Court for ensuring implementation of the order in this effective manner.
Well, the High Court has followed it. Now we are not following it. We'll give you a short date next Monday, please. And counsel for the petitioner filed a letter seeking an adjournment. List on. Give next Monday's date.
Yes. Great.
First. Dismiss the matter. Okay. After the 50 days. State 3.
Because as for office report,
And for the respondent, I'm filing wakalat today, not, I just need a short date, I will file a counter.
Very good.
Lordships had put it for hearing on 13 May, so it couldn't come up. So Lordship may just indicate some date.
We'll give you a date on a Wednesday.
Wednesday, yes, please. That's all I
It was supposed to come up with the week commencing 13th.
Yes, but because of
10
the change.
September. List for hearing on 10 September, pleadings to be completed in the meanwhile.
Grateful.
Obliged.
Obliged.
Item 64. Item 64, note one humble request on behalf of the state law. What is the difficulty? Note they have filed the resignation ROC certificate that we have verified law. But as regard the sister companies are concerned, he was the director at the relevant time law. What we have done, Lord, we have filed a certain transactions note from the account into the sister companies and in his own account note. And I have asked the department to send certain account statement we have received or we have filed, but the relevant period for which the petitioner was the director in sister company awaited law. I may be accommodated for
So he was no longer a company in this bike board.
in company.
Bike board is not there.
He is resigned law.
But he was there in the sister company which received money from bike board, and then he transferred it into his own account.
And even from the sister companies to his own accounts note. This is the CD 186, 183 and 186 disclosure, sir. But I am seeking my lord's permission to file those documents showing that yes, there was a transaction from the sister company to the main company. And
we'll take it up next Monday, Mr.
I have no difficulty except that my learned friend's statement is wrong for two reasons. The bank statements are already here. My learned friend may just show your lordship that he has, in fact, I don't know why he's making this statement because he filed these documents on 19th of August. They're already for your lordship. And none of those, and I must say this,
because you also filed documents till the last minute.
No, this was
night before the matter was listed last time.
My
you
lord,
were still filing
I plead
documents.
guilty and I will accept not what.
Let it verify.
Then may I just say this?
On next.
May I just say this? Don't have it on the first or fourth one.
First, not on first?
No, I'll just tell you first.
Fourth then.
Eighth, if possible.
8th, is it? Very good. 8th September.
Can I make a little suggestion subject to what my learned friend says? The file has become a little voluminous and it's, to be frank, it's a little all over the place. What we'll do is not, I'll give you a lot, we'll just make let my friend.
The compilation.
We'll make a compilation, not and we'll give it to your lordship 3 days back. I will ask my AR to sit with my friend. So it's a common compilation rather than your lordship having to do double work.
Common compilation will be filed by the Learned Council for the parties.
By the
fourth date.
Grateful.
And 65.
Lord, I am for the complainant. Since I was not there before the High Court, I have moved the application also seeking permission to file the SLP. So, Lordship, I kindly turn to page 3, my lord. The only consideration.
There is gunshot residue on the hand of the deceased.
My lord. Yes, I'll explain that. Lord, 3 bullet injuries.
And then you also file a suit. You file a suit and obtain stay order against the accused. In relation to the property, because you are.
But that's a different aspect.
You will perhaps now be the LR.
But I am no, that hand residue I will explain, Lord. I will explain. 3 bullet injuries on the head, Lord. But both of them were in the same room. But the explanation would be that because there was scuffle.
Gunshot residue will come only if you shoot.
Lord, if
not because before the gunshot, if you just
if my hand is on his hand, well, while he's
after he shot you,
when he's shooting, well, that's what I'm submitting. Scuffle.
So while he's shooting you on the head,
who will fire 3 shots in self-defense? 3 shots. All 3 in head.
Lokesh, you're after the property.
No, not at all.
Not about it.
All 3 are.
You file a suit also and secure an order while he's in prison. Then
all 3 in head, Lord. Lordship would consider this aspect, Lord.
You're attacking the mother, saying that she is also responsible, and then the son goes.
There is a
blood. And you get the
gun has been recovered from him only.
Sorry.
The mother has given the disclosure statement explaining how he did it.
Not a case for interference.
But only 8 witnesses out of 38.
Fine, no ground, no good ground and reason to interfere with the impugned judgment. Respectfully, petition is dismissed. Because 66.1. They need to stay the award, not the judgment. 66 is not coming up today. 66.1 alone.
Yes, Your Lordship. On staying the award, not the judgment.
The order dated 8/8/2025 shall stand modified and corrected to the extent of the second paragraph, which shall now read as follows. There shall be stay of operation of the award dated 22/7/2024 till the next date of hearing. AYAN number 195028 of 2025.
All right, Your Lordship, there was one more aspect which Your Lordship may consider. There is one civil appeal number 3705 of 24, NBCC India Limited versus State of West Bengal. My case also gets covered in that, whether on the date of registration of MSME certificate, whether the services can be given prior or after. So my request.
No, but we've already tagged it with this civil appeal.
Okay.
Tamil Nadu Cement. Let it remain with
Oblige,
us.
my lord. Oblige, my lords.
Yes.
Obliged.
67.
Item 67, Lords, I 67, Lords, I got on to in order, my Lords may pass.
No, but has this person been appointed? Because some contempt was filed. You've come with 320 days delay in filing. No, leave that. But because of the contempt, have you appointed?
No, my Lords, the matter is coming up on 5th September.
Before the High Court?
Before the High Court. My Lords, in fact, the only issue really is that I bow down that while he's a minor, we should condone that delay. I am not taking issue.
He became a major in 2006.
Yes, it was that 4 years that he waited because in 2006 he would have
Wanted to finish his graduation perhaps and get a better job.
Yes, my lord, that is what the issue is, but then that is one of the reasons why it has been rejected. So the 15 years delay is not
15
there.
years.
It's not 15 years, my lord, but there is at least that 4 years.
No, but according to your rules, he should,
it's
the
5 years.
compassionate appointment should
5
be
years
within
from
5
there.
years.
But there is.
But she was not in a position, the widow was not in a position to.
My lords, I'm also not quibbling with that. Receive pension, they have agricultural.
Special pension or something you gave her.
Yes, my lords, 1.18 lakhs per year. They have agricultural land. Admittedly, she had 4 minor children when he died, but the petitioner himself.
Issue notice on the condoned delay petition as well as the special leave petition. Returnable on 10th November. Service shall be effected by all modes including justice.
Contempt petition may not be given effect. Unless we can.
We'll have to stay the order. I do not believe in staying contempt proceedings.
Stay the order. That's what.
The impugned order shall remain stayed till the next date of hearing. Operation of the impugned order shall remain stayed till the next date.
I'm very good.
One thing will make clear, operation of the impugned order, if not already implemented, shall remain stayed.
Not been implemented.
Because we don't know what happened before the contempt court, unless you've been given proper instructions.
Have proper instructions, my lords,
But it's not been implemented.
It has not been implemented.
Yes.
Well, there may have been a problem of justice here because my counsel was not here.
We have time and again said miscellaneous applications in disposed of matters.
That is true.
Not proper. You can't ask for an open court hearing by way of a miscellaneous application because a review will not be taken up in open court.
I appreciate the discipline. Give me 2 minutes. Suppose I make a misstatement to your lordship directly, which I'm on the record.
Even then it is a matter for
review.
review.
Lordship when my senior counsel is not
Even then it is a matter for review, not a matter for recall.
This is a very grave miscarriage.
It is not a matter for recall. The registrar is completely justified in saying that this is an abuse.
Well, can I just give one sentence? I just take literally 1 minute. Your lordship's entire order of that day, 17th April, is based on production of original documents. Well, if your lordship
whether the state came to the aid of the complainant and produced record, the ILO gives the documents to him.
I'm
we
telling
don't know.
exactly.
We don't know what happened.
Well, no, Mr. Siddhartha Agarwal could not appear. Your lordships were not told by the complainant that the police has come and given you this, and the police superdari and seizure memo is with me. I gave the documents to the police as a written document.
Not a case for an MA, please.
Whether the inquiry is going on against the police with this kind of then a lordship will say, well, then I will go in my review. I'll immediately file it.
You want to withdraw the application?
Withdraw with liberty. Because what happens?
Applicant, having argued for some time, seeks permission to withdraw the miscellaneous application filed against the registrar's order dated. 29/5/2025.
See, with regard to the fraudulent document or something, a document relating to fraud.
To the petitioner.
Now that the case
Production of original document before them.
Appropriate remedies available to him in accordance with
now that the case is over,
miscellaneous applications have been dismissed as withdrawn with the liberty.
now that the case is over, Melissa, there are 10 pages here which show that the other side's cases are I have the documents. Their case. Unfortunately, that day, whether we not able to put it across, the complainant should have told your lordship. That was the problem. Anyway.
Yes.
Item 69.
May please proceed.
Your 69 perhaps is covered by the earlier order.
Yes,
Vivek Paria. They are not, we've already checked up Arunima Paul. Arunima Paul is differently situated. Arunima Paul is
In
not.
this matter, they have been allowed admission. They are admitted already.
They are.
Applications have been filed by them. When they file the application, they file the application, they'll be sit for the examination.
They will be sitting for.
Yes, they're not an issue. They want, Manoj, that the marks, the process of giving marks should be changed.
Your lordship
process should be changed.
Vivek Paria order will apply.
Exactly.
Your lordship order 21st August.
That's Vivek Paria. They'll be allowed to admit, Manoj. Evidence we have been given admission card.
Candidates who are permitted to be continued service skills also shall be allowed to participate in free selection process without insisting upon their. Yes.
All they have made the applications and they have been given the admit cards also.
Based on
They have been given the admit cards.
based on this order, they are conducting written test on 7th September.
We don't know. We said that the.
They have seconded, they have given the admit card. That record, statement will be recorded.
The others that Vivek Paria case, the
Yes.
applications were yet to be submitted.
Yes. During your lordship order on 21st August, written test is to be held on 7th September.
Very good.
Yes, but 7th September is very short.
No, it's not decided.
Same order, maybe.
Can't get up.
You
Tag along with the very same. Much.
It's not entire. Same.
We'll continue.
We'll continue.
Yes.
Already.
Great.
We should notice.
59?
And tagged it.
But 69, practically your lordships have decided it.
Very well. We've already got Vivek Paria, so let it
No,
come up.
Vivek Paria, we have allowed him. And here they have also allowed. They are challenging the entire rules.
Council has also gone on.
They are
Let it just come up with that. What difference is it?
No,
You don't need to
all
find.
right, all right. All right.
70.
Lot 70
Yes.
is on merits not fully covered by judgment delivered by your lordships. That a remand can be there in exceptional.
I'm appearing for the caveat.
Remand can be done under exceptional circumstances. Please see the paragraph.
Just before my learned friend starts, my lord.
No, but it's a nil award.
Yeah,
my lord,
It's a question of remanding.
I'm only requesting, my lord, your lordship may consider having it on Monday or Friday, my lord. Yesterday night, 8 p.m. my lord.
Issue notice and stay because it's kept on 28th.
Your lordship may consider like this
This is
request.
not a case where the 34 court can now pass an award.
My lord, there are, my lord, the 34 court has passed a completely unreasoned judgment.
Whatever it is. What is the point of it's a nil award. At least if partially some relief was given to
page
the
order.
award.
No, my lord.
It's one thing.
60-page order.
What is a nil award? What is the 34 court going to
Deal
do?
with, my lord, any of the objections that I have raised.
No.
Your lordship may consider, my lord, just having it not next
Extra
Friday.
notice will grant stay of this. You file your
My lord,
reply.
may I?
You're not even on caveat council.
No, my lord, I am on caveat. My lord,
You're not on
caveat
caveat.
is
There's
not
no
registered.
caveat rate.
I'm sorry, my lord. I have filed it on Saturday, my lord. Yesterday night, 8 p.m. I'll be served. Your lordship may just consider, my lord, having it on Monday or Friday, my lord, any date suitable. In fact, my lord, the judgment which my learned friend is relying upon, also, my lord.
17 November. So it shall be affected by all modes, including this thing. Mr. You filed a caveat. I think there's no mention of
Saturday, I have filed, it's not yet registered. I have filed it, my lord. I have the
We won't
caveat.
say anything now. We can't validate your
My
caveat.
lord, in any case, my lord, there is no urgency that.
Then the operation of the impugned order shall remain stayed.
Obliged, grateful. Grateful.
Obliged.
Obliged.
But it's a summary judgment that has been passed in 34. Your Lordship.
We have stayed at council. File your reply.
Well, it's an item 71. We have actually moved the judgment letter. It's not been accepted by the registry. The mediation proceedings are ongoing before.
We've already directed our action. For the petition, takes an adjournment on the ground that in the connected matter, mediation proceedings have been initiated. Based on. When is the other matter coming up?
No date has been assigned. Yes, please.
We'll just give the number, otherwise we'll say flag it along.
We'll get it. That's a copy of this.
72, all the poetry's persons have been granted bail.
No, what is your role? You are Convener Singh.
Yes, I am Convener Singh.
You shot Balbir Singh.
No, my lord.
And also Charanjit Singh.